Speaker.
Almighty God, we give thanks to you, the creator of the universe, and humbly beseech you to direct and prosper the deliberations of the members of this house here assembled for the advancement of your glory and the trust and welfare of the people of Trinidad and Tobago. Grant that peace and happiness, truth and justice may be established among us for all generations. Amen. Amen. Namaste.
Affirmation. Announcements by the Speaker.
Honorable members, correspondence has been received from the President of the Senate, dated June 12, 2019, which states as follows. Dear Speaker, establishment of the Joint Select Committee. Reference is made to your letter dated June 10, 2019, on the subject at caption. I wish to advise that at a sitting held on Tuesday, June 11, 2019, the Senate concurred with the House on the establishment of a Joint Select Committee to consider and report by September 27, 2019, on the Private Security Industry Bill 2019, and the following 6 members were appointed to serve on the committee. Mr. Clarence Rambarat, Mr. Nigel De Freitas, Mr. Foster Cummings, Mr. Saddam Hussein, Mr. Paul Richards, Dr. Varma Dilal Singh. Accordingly, I respectfully request that the House of Representatives be informed of this decision at the earliest convenience, please. Respectfully, Senator the Honorable Christine Kangaloo, President of the Senate.
Bills brought from the Senate on the supplemental order, people. The Sexual Offences Amendment Bill 2019 in the name of the Attorney General. The Bail Amendment Bill 2019 in the name of the Attorney General. Petitions, papers.
Minister of Public Administration.
Thank you, Madam Speaker. Madam Speaker, I have the honor to lay the report of the Teaching Service Commission for the years 2014 to 2017. Thank you, Speaker.
Member for Point of Pear.
Thank you, Madam Speaker. Madam Speaker, I have the honor to lay the delegation report on the 47th meeting of the Board of Directors of the ParlAmericas and the 4th gathering of the ParlAmericas Open Parliament Network held in Quito, Ecuador from March 12th to the 14th, 2019. Thank you.
Reports from committees. Prime Minister's questions.
Whip, I've got some correspondence from you. Do I take it that the opposition is no longer interested in prime ministerial questions today?
I seek clarification first.
No. Are you allowing for prime ministerial questions today or not?
Yes.
Okay, because the questions will roll over, approved and roll over from Monday to allow the prime minister to answer. But I have given the clarification. That's by asking. Member for Oropouche East.
Thank you. Thank you very much, Madam Speaker. Could the Prime Minister indicate the key outcomes of his recent energy-related travels to Europe and North America?
Prime Minister.
Madam Speaker,
I must begin by apologizing for my absence last sitting when I was out of the island and delayed and wasn't able to get back here in time to be of use to the House. So please, Madam Speaker, accept, and members of the House, accept my apologies. Having said that, Madam Speaker, with respect to the question, I simply want to state to my colleague from Orapooch East, and the national community that the answer to that question was offered voluntarily by way of a comprehensive statement to the Parliament by the minister responsible, and the answer is written in the Hansard.
Supplemental member for Orapooch East.
Thank you very much, Prime Minister. Just bearing in mind, Prime Minister, these are the questions roll over to today from Monday because of the then absence of the Prime Minister on that occasion. Prime Minister, would you care to add, therefore, and notwithstanding the statement by the Minister, could you indicate the composition of this traveling party, not only the ministers, but the technical, legal support team that accompanied you, whether any permanent secretary or deputy permanent secretary accompanied you that would keep records for the public service on these important matters discussed and agreed upon?
I will not allow that as a supplemental question arising out of the question. Member for Orapooch East.
Thank you very much. Madam Speaker, could the Prime Minister update the Parliament on the number of Venezuelan migrants so far registered?
Prime Minister.
Madam Speaker, as at 10:27 p.m. last night, Thursday, 13th June, the registration process registered 13,933 Venezuelans.
Supplemental member for Orapooch East.
Thank you very much. Prime Minister, in light of clearly situation of confusion among migrants as to timing and as to numbers, given the crowds we have seen in the social media and in the press, could you confirm whether or not at 5 p.m. today will be the end of this registration process?
Prime Minister.
Madam Speaker, the only confusion that I know about is the confusion that those who are after confusion are referring to. There's absolutely no confusion in the process, Madam Speaker. As a matter of fact, the process has gone relatively straightforward and relatively smoothly and has allowed me to report to you as I have just done. Madam Speaker, in very clear terms, the government has outlined its position and the position of the people of Trinidad and Tobago in providing this window, this 2-week window, where persons who have come to Trinidad and Tobago from Venezuela are able to register and get some relief for a period of 1 year. The period ends today. I do not know at what time, but Madam Speaker, the Minister of National Security and those involved, we are going to be as humane as possible. But at the end of the day, whatever time it ends tonight, that is the end of the registration process. And Madam Speaker, the way it will operate is that those persons who are in the compound, in the vicinity, in the line, those will be the persons at the end of today. Even if the registration process for those individuals is not complete, they will be identified by way of a dated number, which will allow the process to be completed probably tomorrow or Sunday. However, those persons who are at the end of the line today, that is the end of the process of the 2-week registration. It is supposed to end at 5 o'clock today, Madam Speaker. All persons who are there will be identified and acknowledged and be registered in this exercise. After that, Madam Speaker, the normal immigration process
Your time
will
is spent.
apply.
Naparima.
Refer to Princess Strong.
Member for Orapooch East.
My question was answered.
Member for Point of Pear.
Thank you, Madam Speaker. Prime Minister, I just want to seek a little clarification. you said at the end of the day, whoever is identified will be registered, whether tomorrow or whatever. Is those individuals who are on the pavement would be considered, or would the individuals who are in the actual building facility would be considered as being part of that registration process?
Prime Minister.
Contrary to what is being put out by those who want confusion, Madam Speaker, we have orderly lines there, and it will be easy to identify at the end of the day who is at the end of the line, who is there to be registered, and such persons, all such persons who have turned up there and be a part of that line, as at 5 o'clock, if you are there to be registered, you will be acknowledged and identified, and the process will be completed for you. If you are not there at that time, then the process ends and you're not there. And after that, the normal immigration laws will apply. And I don't know what is so difficult in that to understand. And it's only a misrepresentation of that could create any aspect of confusion in any person's mind, Madam Speaker.
Supplemental member for Princess Song.
Thank you, Madam Speaker. To the Honourable Prime Minister. Prime Minister, in light of reports that the website used to register these Venezuelans has crashed as of last night into this morning, can you indicate how or do you see how it will impact on the process in terms of the operations going forward?
Prime Minister.
Madam Speaker, none whatsoever. The online process was only a part of the registration process, and to the extent that you were not able to register online, there are other options available, Madam Speaker.
Member for Caroni East.
Honourable Prime Minister, has your government considered any policy to determine what will happen to the migrants subsequent to this one-year amnesty?
I will not allow that as a supplemental. Member for Couva South.
Thank you, Madam Speaker. Could the Prime Minister inform this House of the cost of the rentals for the Queen's Park Oval, Port of Spain, Achievers Banquet Hall, San Fernando, and Caroline Building in Scarborough, Tobago for the registration of the Venezuelan migrant?
Out of order. Member for Princess Town.
No, Madam.
Member for Naparima.
Speaker, to the Prime Minister, given that over the past 6 months, Heritage Petroleum Company Limited has lost some 20 million to thieves and saboteurs and spent 5 million to replace stolen or damaged equipment, would the Prime Minister advise of the steps taken to secure taxpayers' interests in the property of the former Petrotrin Oil Company?
Prime Minister.
Madam Speaker, Heritage Company, like any other company, has been, in this situation, has been upgrading and improving its security system so as to ameliorate, prevent, or end such wanton misconduct on the part of persons who would harm the company. Madam Speaker, to effect that, where it is feasible, Heritage has been using improved fencing and the installation of CCTV cameras, and they maintain a security patrol system backed up by the national security system of the police with some assistance from the Defense Force.
Member for Naparima, supplemental.
Could the Prime Minister state why, given that the Estate Police Association on the 28th November 2018 warned the government through the Trinidad Petroleum Holdings Board that there would be massive theft and loss of assets following the termination of estate police officers? Could the Prime Minister indicate why those warnings were not heeded?
Prime Minister.
Speaker, I'm not aware of any warnings. What I'm aware of is that that group was offered the first opportunity to be the body responsible to secure the company's assets, and I'm not aware that that came to pass, and therefore I don't know what the member is referring to.
Supplemental. Member for Naparima.
Would the Prime Minister not admit that this whole process of the closure of Petrotrin and the founding of the Heritage and other petroleum companies, that it was badly handled, and therefore the interests of the taxpayers have not been protected optimally?
Prime Minister.
Speaker, I'll admit no such thing. That is the fulmination of a mischievous member of Parliament.
Member for Naparima, supplemental.
I draw the Prime Minister's attention to the EPA's request that was listed in Newsday 2 days ago, and therefore it is factual. Why did they not acknowledge? Why did the Prime Minister does not acknowledge that there's a factual basis for the question I asked on the Estate Police Association?
Member for Naparima, even I have a issue in trying to follow what that question was. Next question, Member for Naparima.
Question 4. Would the Prime Minister state the benefits in monetary and other terms, including any securing of gas deals achieved during his visit to Europe and to Houston?
Prime Minister.
Madam Speaker, in the context of the apology I gave early on, I want to repeat in response to this particular question again, that the government went as far as the government was able to, voluntarily, to outline for the population the answer to this question, which was given by the minister responsible in this parliament by way of a statement in the parliament, and that answer exists on the Hansard.
Supplemental, Member for Naparima.
The Prime Minister indicate whether it was really necessary to go to Houston and to Europe, and these things could not have been achieved right here in the head offices of both companies.
Prime Minister.
If you don't have anything sensible to ask me, why don't keep your seat?
Prime Minister. Prime Minister. I am on my legs. Prime Minister, I really feel that that response should be withdrawn, and you're entitled to give another response that is considered parliamentary.
Madam Speaker, the response is withdrawn. The answer to the question is that the determination of this matter as a part of the responsibility of the Prime Minister of Trinidad and Tobago is a matter to be determined by the Prime Minister of Trinidad and Tobago and the Cabinet, and it was so done.
Member for Naparima.
Question 5 to the Prime Minister. Given clear shortcomings in the current amnesty for Venezuelans, why is the government not giving thought to a comprehensive refugee policy that is consistent with our international obligations?
Madam Speaker, on behalf of the people of Trinidad and Tobago, I can state unequivocally that the government of Trinidad and Tobago, observing the laws of Trinidad and Tobago, have been protecting the interests of the people of Trinidad and Tobago in keeping with all our obligations. And that is our policy. Madam Speaker, the government of Trinidad and Tobago is not prepared to open any refugee camp in Trinidad and Tobago to please anybody except the people of Trinidad and Tobago. And any reference to any shortcoming with respect to other obligations, our primary obligation is to the people of Trinidad and Tobago, and we have done so.
Supplemental, Member for Princess Town.
Thank you, Madam Speaker. To the Honourable Prime Minister. Prime Minister, in this very Parliament, a few months ago, the Honourable Attorney General indicated that there was a policy before the Cabinet with respect to refugees. Can you tell us when that policy will be completed and presented to the people of Trinidad and Tobago?
Madam Speaker, the business of Cabinet will come to the public on completion of any such business. Other than that, Madam Speaker, the business of Cabinet is circumscribed by secrecy.
For Naparima, supplemental.
Is the Prime Minister not mindful and given his obligations to protect the interests of the citizens of Trinidad and Tobago? The question is, why do we not have a data-driven refugee policy that recognizes the absorptive capacity of our country and is based on international best practices?
Prime Minister.
Speaker, it is precisely because the government of Trinidad and Tobago understands the absorptive capacity of Trinidad and Tobago and the people of Trinidad and Tobago why we have conducted ourselves in the way we have, and we will not be encouraged to do otherwise for anybody else's interest on behalf of any lackey.
Supplemental, Member for Caroni East.
Prime Minister, have you considered any comprehensive policy with respect to the children's education?
Prime Minister.
Madam Speaker, The Minister of National Security has addressed that matter early on, indicating the government's position with respect to Venezuelan children in Trinidad and Tobago. Madam Speaker, these are matters that persons in Trinidad and Tobago must understand require a balancing act. And Madam Speaker, the energy coming to me from the other side is in keeping with statements that they have been making, that there are 40,000 and 60,000 and 80,000 Venezuelans there, trying to encourage international bodies to pressure Trinidad and Tobago into converting our country into a refugee camp. You have failed and you will continue to fail.
Thank you, Madam Speaker. To the Honourable Prime Minister, is the Prime Minister satisfied that on the last day of registration during this amnesty period, that on the last day that there is still no policy coming from the government in terms of policy from the cabinet with respect to the current migration problems?
Not allowing that as a supplemental question. Member for Orpuchis.
Is the Prime Minister aware that it have more people at the Oval today than for a test match?
No. I'm not allowing that. Member for Napurima.
Since the Prime Minister indicated that he was aware of the absorptive capacity of the country, I want him to quantify the number of students and the number of patients that our health institutions and our education institutions can accommodate.
Madam Speaker, these fulminations about absorptive capacity and data, the registration process is the first line of gathering data, Madam Speaker, and that is one of the things that will come out of this is to prevent my colleague from Napurima and others from spreading misinformation in the hope of damaging the country. We will have facts and figures and details along those lines to this afternoon going forward. You have to gather data to use data, and the yardstick that we are using, yardsticks, Madam Speaker, which will find acceptance by those who understand our circumstance. We are not the first and only country that is dealing with migrants coming to our shores, where the government has to take a decision whether we allow all and sundry to come in or we restrict it and control it. And we will do what has to be done.
Member for Tabaquit.
Thank you, Madam Speaker. Question number 6 on behalf of the member for Tabaquit to the Prime Minister. Given the recent announcement to the government that persons from Africa detained at the Immigration Detention Center are going to be allowed to register to stay in Trinidad and Tobago, could the Prime Minister state whether the government has embarked upon a policy of accepting any or all persons illegally entering Trinidad and Tobago?
Prime Minister.
Madam Speaker, the answer to that question is no. Once again, we get no understanding or empathy from our colleagues on the other side, and we have to proceed without them. Our country has found itself in a situation dealing with a migrant crisis in Venezuela, not of our doing. Notwithstanding, they're trying to tell people, we who cause Venezuelans to leave home to come here. Madam Speaker, being forced to deal with this situation, another problem which is similar, have come to the fore that we have been grappling with a handful of Africans who are in our detention center, who we are feeding and securing at great cost to us, who we would like to deport. We are taking the opportunity, because we are handling this Venezuelan situation, to deal with 6 Africans, Madam Speaker. If you listen to them, you figure the whole of Africa is in Trinidad and Tobago, upsetting the people. 6 people, of whom, Madam Speaker, 3 are from Nigeria, 1 from Ghana, 1 from the Gambia, and 1 Senegalese. These are the 6 people. And if, Madam Speaker, none of them, if they do not have criminal associations or labeled as criminals, we will take the opportunity, Madam Speaker, to extend to them what we have extended to the Venezuelans and solve a problem for us and for them, Madam Speaker. Contrary to the information being spread by those who do not have the information or those who do not wish us well, there are 6 Africans, Madam Speaker, in the IDC, the Immigration Detention Center. That is what we're dealing with. And that is what the data says.
Supplemental member for Naparima.
Would the Prime Minister not admit that had we developed a comprehensive refugee policy, that we would not have, as an afterthought, identified these 6 Africans and therefore exposed us in a preliminary way to being perhaps racist?
Madam Speaker, I know that my colleagues on the other side will pass up no opportunity to try to damage the government, but please don't damage our country. Madam Speaker, this has nothing to do with race. It's a practical solution. And if we are being called upon to take action, the action of the government of Trinidad and Tobago is comprehensive insofar as the people are concerned. The only people who can't understand what we're doing are those who will not understand, and I'm sure my colleague will never understand this comprehensive refugee policy, immigration policy. Our immigration policy is governed by the laws we have in place. We have no new policy, and we are not being encouraged to put any policy in place which will give us liabilities that we can't discharge. We are discharging our liabilities now in the context of the laws in our books and our own human condition. And whoever is pulling the strings, Madam Speaker, I don't work for them. I work for the people of Trinidad and Tobago. And the laws of Trinidad and Tobago might not be comprehensive enough for you, but it's comprehensive enough to protect the people of Trinidad and Tobago from international interference. And we will brook no international interference in Trinidad and Tobago. We will conduct our affairs in a humane and decent manner, and we can stand scrutiny on the 4 corners of the globe.
Supplemental member for St. Caroline East. Supplemental member for Caroline East. Order, please. Order.
Yes. Prime Minister, have you been able to ascertain whether there are any criminal actions against any of the 6 that you have mentioned who are in the detention center?
I'm not going to allow that as a supplemental question. Member for Napuri.
Prime Minister admit where he heard that the comprehensive refugee policy that we demand, or we ask for, whether that is dictated by international pressure and not the interests of the people of Trinidad and Tobago.
Prime Minister.
Madam Speaker, I've said to the people of Trinidad and Tobago, while there's a demand,
I'm going to take this opportunity to warn everybody on both sides that is standing orders. Member for Laventille West, I know you might be distracted, but I'm on my legs. I'm taking this opportunity to warn all members. Some of us might not have been here for a little time, and we might have forgotten. We are guided by standing orders. On parliamentary language is not going to be tolerated. Shouting across the floor is not going to be tolerated. I assure every member here, if they wish an opportunity to speak, once they catch my eyes and they're within the standing orders, they will get the opportunity to speak. Prime Minister.
Thank you, Madam Speaker. Question number 7 to the Prime Minister. Prime Minister, well, let me read it out, please. Could the Prime Minister state the government's position on the hiring of illegal immigrants by individuals and local international companies doing business in Trinidad and Tobago?
Prime Minister.
Madam Speaker, the government's position is encoded in the laws of Trinidad and Tobago. That is the government's position.
What's your position?
Member for Urupuchi, supplemental.
Thank you very much. To the Prime Minister, as a follow-up question, we have noted the government's policy position that immigrants now with the right to work would not be asked to pay NIS. Would the immigrants who are now entitled to work for 1 year be asked to pay health surcharge?
Prime Minister.
Madam Speaker, the government is taking steps to ensure that the laws of Trinidad and Tobago are observed, and where the laws don't have provision, you would have seen the business of the Parliament so stated to make the rectification so that can be done, Madam Speaker.
Member for Carney East.
Prime Minister, on what basis you made the determination that these immigrants or migrants should not be paying NIS if they are employed? when you're discriminating against those who are employed?
There's one question, and you're allowed 15 seconds. So you've asked it. You've asked it. 15 seconds, Prime Minister.
Why has the Prime Minister differentiated from the migrants from the citizens in not paying NIS?
Very much, Member for Caroni East, for choosing the word differentiated against discriminated. There's a big difference between differentiate and discriminate. It is not a discriminatory action. It's a differentiation, as you quite correctly said. Madam Speaker, the government has provided some element of relief in this way for 1 year to Venezuelans who have come from there under some element of stress. Once you are paying into National Insurance Service, Madam Speaker, there is an expectation and a requirement that the service provides you with benefits. It is because we do not want to add additional persons making claims for benefits on the NIS, while we have separated and differentiated this body of people, while allowing them to stay in our country, but not providing them with access to make claims on the National Insurance Service. That is not discriminatory action. It is a differentiation between citizens of Trinidad and Tobago and persons who have been allowed to stay in our country under special circumstances under this thing which goes on for 1 year. And if that is not clear, Madam Speaker, I don't know what is.
Supplemental, Member for Caroni East.
Answer, Prime Minister. But would that not create an undue advantage or disadvantage to citizens when those employed with businesses have to pay the NIS, the employers have to pay the NIS, but with the migrant population, they're not paying NIS, and therefore the employers not paying NIS. So therefore the businesses now will seek to employ more migrant population because it's cheaper for them than the local population.
Prime Minister.
Madam Speaker, to the extent that that is an overriding consideration, I think, I don't have data, but I don't expect that to be a major consideration in the employment of people, because the business community would have been saying all along in some sectors that they were short of some aspects of the labor force for their particular business. So what it does, on the other hand, is prevent persons from being exploited in an inhumane way if those persons could be threatened with exposure to immigration and therefore had to accept inhumane conditions so as to remain in Trinidad and Tobago. The registration now prevents that from happening, and that is part of the facility that would have been granted to persons who have come to us for help, and that is part of the help that they get. We don't expect this to be a permanent feature. This is a temporary situation. For how long, we do not know. It's a special circumstance, and I think we all can understand that.
Supplemental, Member for Wapuchis. Member for Tabakit.
Thank you, Madam Speaker. Question number 8. On behalf of the member for Tabakit, could the Prime Minister state whether at the end of the 1 year period being given to Venezuelans to remain in Trinidad and Tobago, what would they be repatriated at the end of 1 year?
Prime Minister.
Madam Speaker, clearly this process is open to review because the registration that is going on right now, we have stated up front that the persons who are beneficiaries of that acknowledgement have to be reviewed, turn up again in 6 months' time for a review. At the end of the year, we'll also review. And depending on what is happening around the world in Venezuela and in Trinidad and Tobago, we will take the decisions then depending on what we are dealing with. And this demand for looking around the corner, Madam Speaker, I want to give the country the assurance that what we have got ourselves in is a situation not of our own making, but we are responding in the best that we can so as to ensure that we offer some assistance while not at the same time damaging the wider interests of Trinidad and Tobago. So in a year's time, we'll be in a position to take another decision of some kind. And Madam Speaker, we will be able to do that without fanfare and without problems.
Supplemental, Member for Naparima.
Thank you, Madam Speaker. Is the Prime Minister and the government given consideration to scenario planning, where you could identify possible scenarios and prepare contingency and plans for each scenario?
Prime
Madam
Minister.
Speaker, I am not familiar with the scenario, and therefore I can't respond to it.
Member for Princess Sound.
Thank you, Madam Speaker. To the Honourable Prime Minister. Prime Minister, after the registration process is completed today, could the Honourable Prime Minister indicate what mechanisms will be utilised in order to identify those who have not registered and to be repatriated to Venezuela?
Out of order. Honourable members, the time for Prime Ministerial questions is now spent.
Urgent questions.
Member for Oropouche West.
Thank you, Madam Speaker. On behalf of the member for Oropouche, to the Minister of National Security, with regard to the processing and registration of Venezuelan nationals scheduled to end on Friday, the 14th of June 2019, could the Minister inform this House of the measures which are in place for those nationals who were unable to register?
Minister of National Security.
Thank you very much, Madam Speaker. Madam Speaker, as the Prime Minister has already outlined in a similarly worded question, there is a process in place. At 5 o'clock this afternoon, the registration or the admission of persons being registered will cease. Those who are in the lines, we have already worked out a system that has actually been implemented during the course of this week, over the last few days, where persons who are present in the lines, and we would have identified them prior to that, would be photographs taken of them. They would be given a slip and a chit with a specific unique identification mark on it, and a date on it, and a stamp on it, and a number on it, and that is the way we would be able to complete their specific registration process. So whoever is there at 5 p.m. this afternoon, that is what will apply to them. They will be registered, but after 5 p.m. this afternoon, there will be no more registering of new persons who are not part of the process.
Member for Couva South.
Thank you, Madam Speaker. To the Minister of National Security, in light of the recent protest action by the lifeguards at the Maracas Beach facility and the concerns of members of the public in relation to their safety and well-being, could the Minister inform this House whether he met with the lifeguards' recognized majority union to discuss their concerns?
Minister of National Security.
Thank you very much, Madam Speaker. Madam Speaker, it was not for me to decide the composition of the team that would represent the lifeguards, but yes, we did have a meeting yesterday with 3 representatives from the Lifeguards Association. If he's asking whether Mr. Lambert was there, Mr. Lambert was not there. However, as I say, it is not for me to decide who is the composition of the lifeguard team that presented themselves to meet with the Permanent Secretary at the Ministry of National Security, myself, and the government team to address their concerns. And I must say, the meeting went very well.
Supplemental member for Couva South.
Mr. Minister, you are telling this House that there was no representative from the central executive of the recognized majority union?
Madam Speaker, as I said a short while ago, I don't know to whom he is referring. The Lifeguard Association, the honourable member is referring. The Lifeguard Association was contacted. They presented themselves with their representatives. I assume those representatives were members of the relevant union.
Supplemental member for Couva South.
Thank you, Madam Speaker. Mr. Minister, could you inform this House whether there are health and safety issues existing at other beach facilities in Trinidad and Tobago which may cause lifeguards to pursue similar protest action that was being done at the Maracas Beach facility?
Minister of National
Thank you
Security.
very much, Madam Speaker. Madam Speaker, the dog whistling by the members of the opposition and their continuous dog whistling and their continuous attempts to stir up controversy in the country will not work. I have asked the lifeguards that if they have any issues and any issues of concern, that they should open the channels of communication to the permanent secretaries at the Ministry of National Security, and I myself am available.
Questions on notice, questions for oral answer.
Leader of the House.
Thank you very kindly, Madam Speaker. Madam Speaker, there are two oral questions for oral answer. We'll be answering both. There are no questions for written answer.
Member for Miaro.
Very much, Madam Speaker. Question number 222 to the Minister of Public Administration.
Minister of Public Administration.
Thank you, Madam Speaker. The Universal Service Fund is administered by the Telecommunications Authority of Trinidad and Tobago and is funded by contributions from the telecommunications operators and providers as delineated in Schedule 2 of the Universal Service Regulations. Purpose of the fund. The regulations and the fund are both aligned to international and regulatory best practice, and the main objective is to address affordability and accessibility gaps as it relates to the provision of information and communication technology services in Trinidad and Tobago. The value of the fund as of March 2019 is $120,693,062.93. There are two main projects currently being executed at this time. These are the TT Wi-Fi and assistive technologies. The TT Wi-Fi involves deployment of free public Wi-Fi to a proposed 60 densely populated areas, including waiting rooms in public hospitals and health centers spanning the Northwest, North Central, Eastern, Southwest, and Tobago regions, museums and public libraries across Trinidad and Tobago, including 2 mobile library units, major transportation hubs, water taxi terminals, inter-island ferry terminals, bus terminals, maxi-taxi terminals, and taxi stands, sport and recreational venues, community centers, government offices and centers, shopping centers, tourist sites and attractions. In April 2019, the first component of this project started, which was the rollout of Wi-Fi services to public libraries. Assistive Technologies is the second project and is aimed at providing appropriately equipped mobile phones to the blind and deaf communities. The project is targeted for completion at the end of 2019. Upcoming projects, it includes the continuation of the TT Wi-Fi and broadband infrastructure. The National Wi-Fi project forms one of the main projects going forward. Project implementation is expected in the coming weeks with a project completion date of January 2020 for the national libraries. Subsequent to this, implementation is also planned for hospitals and transportation hubs in 2020. The Telecommunications Authority of Trinidad and Tobago has commenced planning for another project, which is aimed at broadband infrastructure build-out in unserved and underserved communities in Trinidad and Tobago, starting with a pilot project targeted at one community in Trinidad and Tobago. We have yet to identify that community. The planning stage will be completed in this financial year, followed by...
Minister, 1 minute, please. There is some device that is disturbing the proceedings. Can I ask the member with the device to please go out of the chamber, get the device under control, and they can return?
Thank you, Madam Speaker. The planning stage will be completed in this financial year, followed by the tender and award of this project to a service provider with expected completion by the end of 2020. Thank you, Madam Speaker.
Supplemental member from Miaro.
Madam Speaker, Minister, could you identify, if you can, exactly what value of that fund has actually been utilized over the last 4 years since its inception towards the plans that you've now explained to us?
Minister of Public Administration.
Thank you, Madam Speaker. Member for Mayaro, I can provide that figure at another time. Thank you.
Member for Miaro.
Thank you, Madam Speaker. Question number 223 to the Minister of Works and Transport.
Minister of Works and Transport.
Thank you, Madam Speaker. Madam Speaker, during the period 2014-2017, the Ministry of Works and Transport, through the Coastal Protection Unit, conducted the Mayaro-Guayaguari Coastal Study. Through this project, the Ministry have engaged CH2M Hill, conducted a scientific analysis of the problems associated with the coastal erosion and coastal flooding within the Mayaro and Guayaguari Bay. Having done so, the Ministry prepared a long list and a short list of alternative as well as detailed designs, including tender and bidding documents, environmental scoping report for coastal protection measures at 7 priority sites: the Coast Guard facility, Calma Pass, the seawall west of the new fishing facility, Guayaguari Road Bridge, East Guayaguari Village, Central Guayaguari Village, West Guayaguari Village. In December 2017, Cabinet agreed to the inclusion of the Mayaro-Guayaguari Coastal Management Program under the Critical Coastal Protection Program for the period 2016 to 2022, through which the Ministry intends to implement the construction of coastal protection work at the above list sites. The Ministry proposed to commence the Mayaro-Guayaguari Coastal Management Program in fiscal year 2019-2020 and has included for this in the preparation of the draft estimates development program 2020. I thank you.
Supplementary member for Miaro.
Thank you, Madam Speaker. Minister, based on what you said, could you identify or could you explain why priority would have been given to the South Cocos Bay rehabilitation, taking note that there are no houses, no residences in that area, whereas in the Guayaguari Mayaro area, we do have homes that are collapsing into the ocean. Any reason why priority would have been given to the South Cocos Bay rehabilitation?
Minister of Works and Transport.
Sure. Madam Speaker, the honourable member would recognize that the coastal unit, coastal protection unit, will analyze all the different areas. Although there are no houses in that area, if the coastal erosion continued there, what it would have done is cut off the entire Mayaro area, and there would have been no access. So you look at the most critical area, access is just as important to areas as places where there are residents living. If we allow that water to continue, the entire area of Mayaro would be cut off, and the only access to Mayaro would probably be from the southern side of the island. Thank you.
Supplemental member for Miaro.
Thank you, Madam Speaker. Minister, any consideration has been given to working a little closer with the residents in the Guayaguari areas whose houses have been affected in terms of compensation, in terms of relocation and so on? Any conversation has happened between your ministry, the Coastal Erosion Unit, and the residences of the Guayaguari area?
Minister of Works and
Mr.
Transport.
Speaker, the Ministry of Works and Transport does not deal with relocation or compensation. Those two areas are dealt with by other ministries, probably Ministry of Social Development, Ministry of Housing, but the Ministry of Works and Transport do not deal with relocation or compensation. Thank you.
Request for leave to move the adjournment of the House on definite matters of urgent public importance.
Member for Caroni Central.
Thank you very much, Madam Speaker. I hereby seek leave to move the adjournment of the House today under Standing Order 17 for the purpose of discussing as a definite matter of urgent public importance the renewal of the Trinidad and Tobago identification cards for citizens of Trinidad and Tobago by the Elections and Boundaries Commission. The matter is definite because of the case of one citizen, Jasodra Bridgeraj, who is having difficulty to renew her expired TT identification card. The matter is urgent because there are at least 2 elections pending in 2019 and 2020, and a Trinidad and Tobago identification card is important for identification of voting rights on election day. The matter is of public importance because free and fair elections depend on an open, fair, equitable, and efficient renewal process by the Election and Boundaries Commission. Thank you very much. I so move.
Honorable members, I am not satisfied that this matter qualifies under Standing Order 17. Member for Urupuch East.
Thank you very much, Madam Speaker. Madam Speaker, I hereby seek your leave to move the adjournment of the House today under Standing Order 17 for the purpose of discussing a definite matter of urgent public importance, namely, the failure of the government to properly implement a sustainable policy for the management of the migrant crisis. The matter is definite because it pertains explicitly to the breakdown and loss of control of the influx of thousands of migrants who have illegally entered our country. The matter is urgent because today marks the end of the ill-advised and ill-conceived registration process, notwithstanding thousands of migrants remaining on the street unprocessed. The matter is of public importance because the failure of the government to protect our borders has led to an historic invasion by illegal migrants.
Honorable members, I am not satisfied that this matter qualifies under this standing order.
Statements by ministers, personal explanations, introduction of bills, motions relating to the business or sittings of the House and moved by a minister, public business, government business, bills second reading.
The Minister of Finance.
Thank you, Madam Speaker. I beg to move that a bill entitled An Act to Provide for a Tax Amnesty in relation to certain revenue laws and to amend the Retiring Allowances Legislative Service Act, Chapter 203, the President's Emoluments Act, Chapter 250, the Prime Minister's Pension Act, Chapter 251, the Judges' Salaries and Pension Act, Chapter 602, the Freedom of Information Act, Chapter 2202, the National Insurance Act, Chapter 3201, the Central Bank Act, Chapter 7902, and the Non-Profit Organizations Act 2019, Act Number 7 of 2019, be now read a second time, Madam Speaker. Madam Speaker, there are a number of measures which the bill before the House seeks to address, Madam Speaker. The particular acts that are being affected are the Retiring Allowances Legislative Services Act, the President's Emoluments Act, the Prime Minister's Pension Act, the Judges' Salary and Pension Act, the Freedom of Information Act, the National Insurance Act, the Central Bank Act, and a number of pieces of legislation that refer to the imposition of tax and the collection of tax from persons with respect to individual income tax, corporation tax, petroleum profits tax, supplementary petroleum tax, value-added tax, petroleum levy, green fund, business levy, hotel tax, insurance tax, and a number of other taxation measures, Madam Speaker. The bill before us has 10 clauses, and amendments were submitted on the last occasion. And let me just say that the government intends to proceed with these amendments and also to proceed with any other amendments that may be recommended by members opposite that are appropriate and are found to be appropriate and consistent with the policy. In the list of amendments, Madam Speaker, let me go through it briefly. This is a list, and It gave notice. It was circulated on the last occasion 1 week ago, and it gave, or Monday, sorry, it was circulated on Monday, my apologies, and it gave notice that the Minister of Finance will move a series of amendments, Madam Speaker. There are amendments to the list of laws that are going to be subject to the tax amnesty, including the registration of clubs, where there will be an amnesty on gaming and gambling taxes for gambling devices and so on, an amnesty on health surcharge, an amnesty on outstanding land and building taxes. And this is an interesting one, Madam Speaker. Even though the Land and Building Taxes Act was repealed in 2009, at that time, there were a number of persons who still had unpaid land and building taxes. And Section 54, I believe, Madam Speaker, of the Property Tax Act, and you will see in this bill, the original bill, the one without amendments, you will see that the Section 54, I believe, of the Property Tax Act, it's in the amendments, Madam Speaker. Section 54 of the Property Tax Act is now going to be invoked, and that section states that any outstanding land and building taxes that were due and payable upon repeal of the Land and Building Taxes Act are still due and payable. That was what was done 10 years ago. I will come back and state the exact section, but I'm pretty certain it's 54, subject to correction. So that there are a number of persons who still owe land and building taxes from 10 years ago. And when they go to transfer property, this is when it comes up. When you have a conveyance, a transfer of title of property, the mortgage institutions require that all outstanding rates and taxes be settled by the vendor before the purchaser can receive title to the property. So that there are a number of persons who find themselves stuck because they have not paid their land and building taxes from 10 years ago. They wish to engage in sale of property, and the mortgage institutions are insisting that they clear it. But because they didn't pay 10 years ago, there are substantial penalties and interests that have accumulated over the last 10 years. So this addresses that anomaly and allows persons to avail themselves of this provision, so we can now have a cleaning up of outstanding land and building taxes under the old Land and Building Taxes Act. I was to reiterate, although the act was repealed, there was a particular provision in the Land and Building, the Property Tax Act of 2009 that maintained the liability for land and building taxes. The purpose of the tax amnesty, Madam Speaker, is to allow persons to bring their taxes up to date in terms of their returns in particular. A number of persons would not have submitted tax returns for one reason or another. And there's a penalty for the non-submission of a tax return. And this penalty builds for every year that the return is not submitted. Interest accrues on outstanding tax, and it builds for every year that the interest is not paid. So the purpose of the tax amnesty is to give a 3-month window. And although today is the 14th of June, and we are currently debating this matter in the House, and I'm told it will go to the Senate on Monday, which would be the 17th, the Board of Inland Revenue, by using their administrative powers, is already going to begin to receive payments of taxes and submission of returns from Monday, the 17th, although this bill may not come into effect until Tuesday or Friday of next week. They're allowed to do that. So they will not impose the penalties because this act is conferring a benefit, and you're allowed to have retrospective application of legislation if it confers a benefit. If you are taking away something from somebody or imposing a liability or penalty on them, you need a special majority for that. But when you are conferring a benefit, and this House has done that many times under many different governments, you do not require a special majority for retrospective application. So the amnesty does take effect from Monday, and the law will apply retrospectively from the time it is assented to by the President, I do expect there may be some amendments from the other place so that we may have to meet. I'm just telling you all that depending on what occurs in the other place, we may have to meet on Tuesday for a brief period to approve amendments coming from the other place, which would mean this act will probably take effect on Friday. And it will be assented to on Friday. Let me correct that, but will take effect from Monday. So I just want to clear that up. The last tax amnesty by this administration was in 2016. It was for a period of 2.5 months. And the target at that time was $500 million. But in that 2.5 months, we collected $750 million. Now, I've noticed that there's some commentary in the media, in the papers, from persons who should know better with respect to how much we collected from the amnesty on the last occasion. And we're talking about experts, persons who come from accounting firms and have a long list of qualifications behind their name. I've seen these comments in the papers that the government's target of $500 million from this amnesty is unrealistic because on the last occasion we didn't meet our $500 million target. That's nonsense. On the last occasion we got $750 million and the tax amnesty was for a shorter period. So I see no reason why not. I see no reason why we will not be able to meet our target of $500 million, and I rather suspect that we will exceed our $500 million target. And this will assist in no small measure with respect to offsetting some shortfalls of revenue that we had in the first quarter of the year because of depressed oil prices. Those of you who follow oil prices would have seen that from October to December, there was a significant drop in oil prices. That affects the collection of supplementary petroleum tax in particular, and the collection of royalties, because supplementary petroleum tax kicks in when the oil price is above $50, and royalties are based on the actual oil price. So if you have an oil price that is lower than $50, which occurred at one point in time between October and December of last year, the supplementary collections of tax is severely diminished. I'm talking about the reference price, WTI in Trinidad, though we get slightly higher prices. We get close to Brent for some of the East Coast oil, and as you may have heard, the Heritage Petroleum oil, which was said to be of no saleable value and no good, is in fact attracting prices of up to $5 more than WTI. But anytime the oil price drops, supplementary petroleum tax drops and royalties drop, so that this amnesty will go in some considerable way to dealing with the shortfall in collections of supplementary petroleum tax and royalties in the first 3 months of this fiscal. And in fact, the depressed oil prices continued throughout the second quarter and even into the third quarter now. Last time I checked the oil price, it was in the 50s, $53 or something like that, and we had budgeted $65. It was in fact $70 just before budget day. So it just shows you the volatility of oil prices. The IMF forecast for oil prices at the time of the budget last year, October, was $69 for 2019. The World Bank estimate was about $68. The United States Energy Information Administration estimate was $70. So that it's very, very difficult to predict oil prices. We pegged it at 65 based on the targets set by all the international agencies, the respected agencies. It has not averaged that. It is below 65. So as I said, this amnesty will go into some way in dealing with that. If I go through the bill itself, the tax is defined also to include a levy. So that deals with business levy and green fund levy. For the purposes of this legislation, those two items are defined to be tax. So that's why we have not cited green fund levy and business levy. We have simply said any outstanding tax and defined the levy to be tax. And this bill is a little different from what was done before. What we have done in this bill is that we have indicated that notwithstanding any written law to the contrary, there shall be a waiver of the following liabilities in relation to any tax payable under revenue law: interest on any outstanding tax, outstanding interest charge on any tax, all other penalties due and payable on outstanding tax, penalties on outstanding returns, because there's a penalty if you don't submit your return, and in addition, penalties within with respect to current returns, Madam Speaker. And we've used the form of words that there's a waiver of liabilities in relation to any tax payable under a revenue law. And revenue laws are defined in the schedule, in the unamended schedule. It's Income Tax Act, Corporation Tax Act, Petroleum Taxes Act, Value Added Tax Act, Part 10, Part 9 of the Miscellaneous Taxes Act, Income Tax in Aid of Industry Act, Tourism Development Act. And when you look at the list of amendments, Madam Speaker, we are adding the Registration of Clubs Act, the Unemployment Levy Act, the Health Surcharge Act, and it is in fact Section 54 of the Property Tax Act. And we are also dealing with typo in the original bill, which was Part 9 of the Miscellaneous Taxes Act, and substituting Part 9, 11, 13, 14, and 15, and these deal with taxes such as the hotel tax and so on, Madam Speaker. So what we've tried to do in this amnesty is to cover all types of taxes and levies that are subject to interest and penalties for late payment. So we are waiving the penalty on all interest and penalties that are due and payable on outstanding taxes of virtually every type. So we've tried to make this an all-embracing and all-covering amnesty. And as I said, we have defined a levy to be a tax, so we cover the Green Fund levy and the business levy. So that is the purpose and intent of the tax amnesty. And Madam Speaker, you will know that a report has been submitted to this House with respect to the Trinidad and Tobago Revenue Authority bill, and I can announce that it is the intention of the government to debate that legislation before we go on recess, so that what we're trying to do is to give persons an opportunity to clean up their system, pay their taxes before the introduction of the Revenue Authority, Madam Speaker. Moving on now, Madam Speaker, to retiring allowances. Madam Speaker, I have taken note of a lot of misinformation in the system with respect to existing law. And I thought it appropriate to bring into the Parliament some information on existing law as it relates to pensions generally in Trinidad and Tobago. And I've noticed, Madam Speaker, persons who held senior positions within the public service, including retired permanent secretaries, making statements in the public domain, which have been widely reported in the press, that the redefinition of the term pensionable emoluments is unprecedented, has never happened, does not exist anywhere in law in this country. And I want to repeat that. I have noticed retired senior public servants, who have held the office of permanent secretary and others making statements that the amendment to the definition of pensionable emoluments does not exist in law, is unprecedented, and is out of this world. I want to read into the record, Madam Speaker, an extract from the Pensions Act, Chapter 2352, an act to regulate pensions, gratuities, and other allowances to be granted in respect of the public service of officers in Trinidad and Tobago. So this is the act that regulates pensions and other benefits after retirement for public servants, especially senior public servants, Madam Speaker. This act is number 16 of 1934. 1934. The Pensions Act has been in existence for 85 years. 85 years. And in this act, which was first assented to on the 1st of August, 1934, this is the definition of pensionable emoluments for senior public servants. Pensionable emoluments in respect of service under the government of Trinidad and Tobago includes salary, personal allowance, inducement allowance, house allowance, or the estimated value of free quarters and any fees paid out of the Treasury by way of salary, except that the amount to be allowed for house rent or estimated value of free quarters shall not exceed 1/6, nor the amount to be allowed for fees 1/4 of the actual salary of the office. I wish to repeat, Madam Speaker, this is Act number 16 of 1934. 85 years this act has been in existence, where senior public servants' pension is calculated not just on their salary, but on a number of allowances. And let me read those allowances again. Personal allowance, inducement allowance, house allowance, Madam Speaker. 85 years. So what we sought to do with respect to other servants of the government of Trinidad and Tobago, because let me repeat what this act says. In respect of service under the government of Trinidad and Tobago, this is what the pension of these servants of Trinidad and Tobago is calculated by. So in respect of other servants of Trinidad and Tobago, namely the President, the Prime Minister, members of Parliament, government ministers, legislators, and judges, I think it is only fitting that if senior public servants and persons in the service of the government have been eligible to receive these benefits since 1934, that, including the persons who are outside there talking, saying that this is unprecedented, unheard of, not allowed, don't exist, that these persons have been receiving these pensions based on this formula, Madam Speaker. So I just thought I would put that into the record. So what the government has done is not arbitrary. It is not whimsical. We are harmonizing existing laws. And we are leveling the playing field and making it equal for persons who are servants of Trinidad and Tobago, Madam Speaker. Facts are facts. So, Madam Speaker, what the bill seeks to do is to redefine the pensionable emoluments of legislators under the Retiring Allowances Legislative Service Act, the President under the President's Emoluments Act, the Prime Minister under the Prime Minister's Pension Act, and judges, including the Chief Justice, under the Judges' Salaries and Pensions Act. And it is very similar to what currently exists for permanent secretaries and other senior public servants, those who are in receipt of a housing allowance. That particular definition of pension emoluments applies to every public servant who retires who was in receipt of those allowances: inducement allowance, personal allowance, housing allowance, fees, and so on. So it's simply making this group of people in harmony with that group of people, Madam Speaker. With respect to the other significant amendment in the pensions, what we have done is we have harmonized the pensions of judges, the Prime Minister, and legislators with what already exists in the President's Emoluments Act, Madam Speaker. And this was something that was done by this Parliament some years ago, and those of us who were there and participated in that amendment will remember this. And I do recall the member of Siparia. I definitely recall the member of Siparia being present and participating when we amended the President's Emoluments Act. And this was done in the year 2009. The member of Siparia was then in the opposition, as far as I can recall. I can't remember who was the leader of the opposition at this particular time in 2009, but I do know that the member of Siparia was a member of Parliament in 2009, and this was Act 12 of 2009. And I can't recall. No, there was, I know there was a, it does. I know there was a transition, Madam Speaker. I know there's a transition between 2009 and 2010. Madam Speaker, it is unfortunate that members opposite, when reminded of their participation in something, would choose to deny. So In 2009, we introduced an amendment to the President Emoluments Act saying that every person referred to in Section 3.1, and that would be the President, is eligible on every 6th anniversary of the date he ceased to be President for a revised pension equivalent to the salary payable to the incumbent on that date. We have decided that we should make the period for the President and everybody else 5 years instead of 6, because 5 years is the term of office of a parliamentarian, it is the term of office of the President, and so on. So we thought that we should make it 5 instead of 6, simply to make it harmonious with existing provisions. And we are extending this provision, we are harmonizing this provision with respect to the other categories of persons, judges, legislators, Prime Minister, Madam Speaker. What this will do, where you have persons such as a current retired Chief Justice, Madam Speaker, a current retired Chief Justice who receives a pension in the vicinity of $10,000 a month, a current retired minister of the Pandey administration who currently receives a pension less than $10,000 a month, several members of parliament from the 1986 and 81 parliament, there are still some of them still alive who receive pensions that are in the vicinity of $5,000 a month. This will allow persons like that, and I can speak from personal experience that when I became Minister of Finance, there was a former legislator, not a member of the PNM, who approached me and indicated to me that in his declining years, this person is now quite elderly, he had medical problems, his family had medical problems, and his parliamentarian's pension was even insufficient to pay his medical bills. So that after he paid his medical bills with his parliamentarian's pension, he still was in deficit, Madam Speaker.
Wants to sell his house.
And yes, so that after this retired legislator paid his medical bills, he was still in deficit because his entire pension was consumed in paying his medical bills because of existing provisions where his pension is less than $10,000 a month. And then, as I said, there are others whose pension is $5,000 a month, Madam Speaker. And there's a retired Chief Justice whose pension is $10,000 a month. I remember judges who have since passed away. One of the things about being the Member of Parliament for Dega Martin Northeast is that there's a high proportion of judges who live in my constituency, Madam Speaker. So I would meet retired judges from time to time, not sitting judges. I don't interact with sitting judges. But I would meet retired judges from time to time in church and other places. And I remember a particular judge whose pension was $3,000 a month, Madam Speaker. $3,000 a month. Could not maintain his house. I think you know who I'm talking about. Could not maintain his house. And passed away in poverty, Madam Speaker. I remember that. When I first was elected as the MP for Dega Martin Northeast, and on one of my walkabouts in my constituency, I encountered this particular retired judge who retired in poverty and passed away in poverty, Madam Speaker, because of these existing pension arrangements. As I said, his pension was about $3,000, might even have been less. You know, I remember it's $2,000 something per month, Madam Speaker. So that this is what I have to say with respect to our amendments to our Pensions Act. And I want to correct some misinformation that's in the system. And I am sure the Member of Parliament for Siparia was not reported accurately. Can't be, because the Member of Parliament for Siparia is a very experienced legislator. I saw a report that the Member of Parliament for Siparia was claiming that we in the government want to increase our salaries, Madam Speaker. That was widely reported. And I'm only assuming that that the honourable member was misquoted. Yes. What we are dealing with here, Madam, I did not say it. I saw it in the papers. I saw it on TV. I heard it on the radio. And I'm just assuming that the honourable member for Siparia was misquoted, because we are not here dealing with our salaries. We are dealing with retirement benefits for people who have served this country well and to address a situation where you have retired legislators, retired judges who are in poverty, Madam Speaker. People laugh at them. You know, somebody has attained the status of a judge or attained the status of a member of parliament or a government minister, and they retire and their pension is a couple $1,000s a month. People laugh at them, Madam Speaker. And I think as parliamentarians, we must have a conscience and rise above the temptation to be political about everything. So I will not say anything more about pensions, Madam Speaker. I will just repeat that the definition of pensionable emoluments that we are seeking to harmonize for all of these categories of persons already exists in the Pensions Act for public servants and has been there since 1934. And that the current situation where the pension of these persons who have served their country for decades, in particular judges who have served their country for decades, because of the way the law is worded, find themselves in very, very difficult circumstances. I do not intend to say anything more on this, Madam Speaker. I think I've addressed the salient issues, and I will leave it up to other members to say whatever they have to say about this. With respect to the Freedom of Information Act, Madam Speaker, I will leave the bulk of this matter for my learned colleague to my left, the Member of Parliament for San Fernando West, the Attorney General, to deal with. But all I would say, I'll just say one thing. We have a tendency in this country to misrepresent the facts. And I have seen over the last week deliberate misrepresentation of the facts, distortion of the facts, untruths, outright untruths, permeating the commentary on this matter. Imagine, Madam Speaker, the purpose of this amendment is when a public authority decides it is not going to disclose information, the amendment allows the Attorney General to overrule that decision and disclose the information. So this amendment is when a public authority says, no, I'm not going to disclose information, the Attorney General can turn a no into a yes. It gives the government the ability to deal with a public authority, a statutory authority, a state enterprise who is refusing to disclose information. It gives the Attorney General the authority to instruct that authority to release the information. It is the complete opposite. It's the complete opposite of what is outside there. It is improving the law so that errant statutory authorities and errant state enterprises will no longer be able to refuse to disclose information, and the Attorney General will turn a no into a yes. And that's all I have to say. And for an entire week, I have to hear that this amendment is designed to hide information. That's what it is, but I'll leave it to the Attorney General. Now let me move on, Madam Speaker. The next amendment is the amendment to the National Insurance Act. What this does is allows the Cabinet, acting on the advice of the Minister of Finance, to whom the National Insurance Board reports, to recommend exemptions from national insurance in special circumstances. Right now, we have no such provision in the Act. There are provisions of that type in the Income Tax Act. For example, the Cabinet, acting on the advice of the Minister of Finance, can waive customs duties, value-added tax, and other forms of taxation on imported goods, and it's done all the time. I would say every other week, the Minister of Finance has to make a submission to the Cabinet, and it is not unique to this Minister of Finance. It has happened to all Ministers of Finance. You have sporting teams coming in for special events. You have ships coming in to deliver items like cement to Tobago and so on. It happens all the time. And the current law, the way the current law is structured, if you import something into Trinidad and Tobago, tax and duties due and payable. But the framers of the laws, in their wisdom, gave the Cabinet the authority to exempt from tax certain categories of imports, Madam Speaker, for special purposes and for goods that are coming in for a very short period of time and being exported, Madam Speaker. This also exists in other laws. It exists with respect to motor vehicle tax. It exists with respect to port rent and so on, Madam Speaker. but it does not exist in the National Insurance Act. There is no provision in the National Insurance Act to allow the government, the cabinet, to exempt from the provisions of the national insurance system anybody. So this provision is designed to deal with that. There is a point of view that is designed only for the current registration of Venezuelan migrants, but that is only a small part of the story. As usual, this will allow persons to be exempt from NIS if they come in for short periods, Madam Speaker. What is the point of insisting that somebody registered for NIS if they're only here for a very short period of time, Madam Speaker? The paperwork alone in processing that application would cost more than the contributions received and the benefits, Madam Speaker. So this is simply an improvement to the law to give the Cabinet the ability to exempt NIS. With respect to health surcharge, I heard this in a question. Health surcharge is a tax, and therefore health surcharge is already covered under Section 123 of the relevant act. Or taxes, the exemption of taxes is covered under Section 123 of a relevant act, and there are other provisions within other acts such as the Value Added Tax Act and so on. There are provisions that allow the Cabinet, acting on the advice of the Minister of Finance in a multitude of acts, to exempt from tax, exempt tax with respect to certain matters. So the exemption with respect to health surcharge is not necessary. That power already exists. And in any event, Madam Speaker, if somebody's going to be registered for tax, then they have to pay health surcharge. So if somebody has to be registered for tax, then they have to pay health surcharge. So if somebody is earning more than $6,000, they will have to pay health surcharge. That the exemption does not come into play there. No, Madam Speaker, I've heard some old talk from over there. I just want to repeat that once a person is above the personal allowance, they have to pay tax. And they have to pay all forms of tax, Madam Speaker. All forms of tax. And you see, Madam Speaker, the misinformation outside there that Venezuelans don't have to pay tax. Nonsense. Income earners in this country, once they earn $6,000 or less per month, $72,000 for the year, are exempt from tax, Madam Speaker. PAYE, I'm talking about, pay as you earn. So, Madam Speaker, the health surcharge will not be exempted. And even if you're not earning that amount, you still have to pay health surcharge, Madam Speaker. And if you're earning $4,000 a month, $5,000 a month, you have to pay health surcharge. So that should get that health surcharge argument out of the way. Let me move on now to Section 56 of the Central Bank Act. Now, this is the most interesting one, and I intend to spend some time on this. Madam Speaker, I have seen commentary in the newspapers that makes absolutely no sense. Absolutely no sense, Madam Speaker. Absolutely no sense. We in this country, Madam Speaker, have some archaic laws which, when they were drafted, created anomalies in the system that, on reflection now in an evolving society, make absolutely no sense, Madam Speaker. Madam Speaker, I have seen some statements in the newspapers that this is unprecedented, doesn't exist anywhere else in the world. Well, Madam Speaker, let me go to somewhere very close to home. Let me go to Jamaica, Madam Speaker. And for those who wish to know, because a lot of the commentary outside there is self-serving, a lot of it is just wild, speculative commentary. A lot of it is not based on fact. It is not evidence-based. It is not data-driven. Just people talking. So let us go now to the Bank of Jamaica, the act that created the Bank of Jamaica in that country, Madam Speaker, that CARICOM country. And in that CARICOM country, Madam Speaker, in Section 8, states, Section 6, subsection 8, it states the governor, senior deputy governor, and deputy governors shall be appointed by the minister by instrument in writing for a period not exceeding 5 years on such terms and conditions as may be specified. So in Jamaica, the Minister of Finance sets the salary and terms and conditions and allowances of the governor, the senior deputy governor, and the deputy governors of the central bank. That is what is done in Jamaica, Madam Speaker. Section 7 of the Bank of Jamaica Act, Madam Speaker, state that an annual salary exceeding the prescribed rate shall not be assigned to any post without the prior approval of the minister, and no appointment to any post to which an annual salary exceeding the prescribed rate is assigned shall be made without the prior approval of the minister. So in Jamaica, the Minister of Finance has to approve the salaries and allowances of every single employee of the central bank, Madam Speaker. And the minister establishes the initial rate, and if the bank wants to go above that, they have to come back to the minister for approval, Madam Speaker. Let me move on. I am simply, Madam Speaker, I'm speaking to you, and I'm dealing with what is in a CARICOM country, Madam Speaker. Section 11 of the Bank of Jamaica Act states, Madam Speaker, 47.3, every officer and servant of the bank and every auditor of the bank shall not communicate any such matter, and the matters are all matters relating to the affairs of the bank, very similar to what we have in our Central Bank Act. Our Central Bank Act speaks to matters relating to the affairs of the bank. In Jamaica, every officer and servant of the bank shall not communicate any matter relating to the affairs of the bank to any person other than a person authorized by the minister. So in Jamaica, the Minister of Finance can authorize the central bank to disclose anything with respect to the central bank. Oh, I'm coming to England. I'm coming to England, Madam Speaker. So that in Jamaica, Madam Speaker, the Minister of Finance can acquire and disclose any information with respect to the Central Bank of Jamaica, Madam Speaker. In India, Madam Speaker, the only information that is not disclosable is credit information, Madam Speaker. In other words, the identities of persons who have taken loans and persons who have really banking relationships. And I'm reading from the Central Bank of India, Madam Speaker. With respect, Madam Speaker, to the Central Bank of Australia, Madam Speaker, again, that act allows disclosure, Madam Speaker, to the minister. Now, let me read. Producing a protected document for the purposes of exercise of its function and powers of the Reserve Bank, if the disclosure or production to the minister is allowed. Australia, any information, Madam Speaker. In Barbados, Madam Speaker, the bank is required to disclose anything that the minister requires with respect to the purposes of the bank, Madam Speaker. Everything, Madam Speaker. And now, Madam Speaker, what I find terribly perverse in some of the commentary I've seen outside there, Madam Speaker. What I've seen terribly perverse outside there, Madam Speaker, is that members of the commentators are demanding freedom of information from the government. The commentators are condemning the government to give more freedom of information, condemning the government for interfering with the Freedom of Information Act, making a set of noise about how sacrosanct is the public's right to know, demanding disclosure of any and all information as it relates to international treaties, relationships with foreign governments, matters that are protected by privilege in arbitral tribunals. The commentators outside there saying all of this must be disclosed. All of this must be disclosed. But when it comes to the central bank, nothing must be disclosed. The same commentators, Madam Speaker, same commentators are stating that it's fine for disclosure about the Office of the President, the Office of the Prime Minister, all state enterprises, all public institutions, all government departments, all ministers of government, the Parliament. It is fine and correct and right and proper that there be full disclosure of information with respect to all of these persons and institutions, but not the central bank. This is so out of step with the rest. This is so out of step with the rest of the world. Yeah, I'm coming to that. This is so out of step with the rest of the world. Imagine we have people in this country, Madam Speaker, who are so... How much time I have?
You have 20 seconds left.
Full time? Madam Speaker, in all over the world, Madam Speaker, the salaries of senior officers of central banks are published as of law. In Australia, in the United Kingdom, in Canada, it is the law that the salaries and terms and conditions of employment of officers of central banks are published. It is the law. It is only in Trinidad and Tobago that this should not be the law. I beg to move, Madam Speaker.
Honourable members, I shall now propose the question for debate. The question is that a bill entitled An Act to Provide for Tax Amnesty in relation to certain revenue laws and to amend the Retiring Allowances Legislative Service Act, Chapter 203, the President's Emoluments Act, Chapter 250, the Prime Minister's Pension Act, Chapter 251, the Judges' Salaries and Pension Act, Chapter 602, the Freedom of Information Act, Chapter 2202, the National Insurance Act, Chapter 3201, the Central Bank Act, Chapter 7902, and the Non-Profit Organizations Act 2019, Act Number 7 of 2019 be now read a second time. Member for Couva South.
Thank you, Madam Speaker. As I'm very pleased to join this debate on behalf of the opposition and indicate to those on the other side that this opposition led by the member for Siparia is about presenting the facts to the people of Trinidad and Tobago as they see it. This is not about distortion. This is about fulfilling our responsibility under the Constitution of Trinidad and Tobago, Madam Speaker, and we will speak out in the Parliament and outside of the Parliament, Madam Speaker, because we are not about suppressing freedom of information and freedom of expression in this country, Madam Speaker. Our track record speaks volumes for itself under the leadership of the member for Siparia. Madam Speaker, and the member for Diego Martin Northeast, the Minister of Finance spent a lot of time on the issue of taxation and the amnesty and pensions and so on, and retiring allowances, Madam Speaker. And he also went on without any sense of rationale to really attack And I found that it was in poor taste to attack persons who have given service to the development of this country, such as retired public servants and permanent secretaries and so on. I thought that that was not a patriotic act on the part of the Minister of Finance, Madam Speaker. And he focused on the servants of the people and serving Trinidad and Tobago, Madam Speaker. And in that regard, he went in the direction of focusing on the pension of judges and retired public servants and so on. We all have a responsibility, Madam Speaker, to ensure that persons who have served Trinidad and Tobago at all levels have a pension that they can live on, Madam Speaker. And I want to ask the Minister of Finance, because we are on the eve of Labor Day. Today is the 14th of June, and on the 19th of June, Madam Speaker, we will commemorate or celebrate the 82nd anniversary of the labor riots and the birth of the modern trade union movement in Trinidad and Tobago, Madam Speaker. And Madam Speaker, pensions are important to all persons in this country. And my sources in the trade union movement, Madam Speaker, my comrades, my brothers and sisters in the trade union movement, Madam Speaker, they have told me that they have written 4 letters to the Minister of Finance seeking to address their outstanding negotiation for 2 periods, and not 1 letter has found favor to even be acknowledged by the arrogant Minister of Finance as it relates to addressing their negotiations. And certainly, Madam Speaker, their final salary based on negotiation settlements and so on will indeed contribute to a pension of well-being, Madam Speaker. But more importantly, Madam Speaker, my other colleagues will deal with a number of issues in this particular piece of legislation, because everyone on this side is very competent to fulfill our responsibility, Madam Speaker, speaking on behalf of the people of Trinidad and Tobago, Madam Speaker. And Madam Speaker, this debate, as I said, focuses on the miscellaneous provisions in relation to tax amnesty, pension, freedom of information, national insurance, the central bank, and non-profit organization bill of 2019, Madam Speaker. And it is important, as I said just a couple moments ago, that on the 19th of June, we will focus on or celebrate. I do not know if the workers of Trinidad and Tobago and the labor leaders of Trinidad and Tobago can find anything to celebrate after 4 years of tyranny under the government of Prime Minister Dr. Keith Rowley, Madam Speaker. And our labor leaders, such as Adrian Kolarienzi, more popularly known as Krishna Devanarayan, and Tubal Ridra, Buzz Butler, and Bade Sagan Maraj, and Nathaniel Critchlow, Vernon Glean, and Kenrick Rennie, Francis Mangro, Boise Moore Jones, and so on, will be rolling in their graves based on this legislation, which for me is the most dubious piece of legislation that has been tabled by the government of Prime Minister Dr. Keith Rowley, Madam Speaker. And Madam Speaker, the crux or the focus of my contribution will be on Clause 8 of this particular piece of legislation, Madam Speaker. Clause 8 of this bill will seek to amend the National Insurance Act, Chapter 3202, to empower the minister to prescribe by order that certain persons who are registered as employed in uninsurable employment during a specified period of time, Madam Speaker. And Madam Speaker, the Minister of Finance, in piloting this legislation, indicated that the amendment to the National Insurance Act will be something along the lines of where the cabinet can intervene to exempt taxation as it relates to motor vehicles and port rent, and he went on and indicated that it will allow persons also coming in for short periods. I do not know what he meant by short periods, because if this is subject to the cabinet and what I would call by order based on the Minister of Finance going to the cabinet, this is something that can emerge to be arbitrary, and every Monday morning, the Minister of Finance and the cabinet could be interfering in relation to the national insurance system, Madam Speaker. And I do not know what will really be the improvement from this angle, Madam Speaker. But Madam Speaker, when we pass legislation in this House, we have a responsibility as legislators to be guided by what we would call visionary policy, Madam Speaker. Policy that is forward-thinking, and certainly I cannot say that we have heard from the Minister of Finance that in relation to the policy, if it is clear-cut, if it is visionary, and I could say certainly it is chalk and cheese in comparison, because under the Member of Parliament for Siparia, under the partnership government, whenever we brought law into the parliament of this country, it was based on visionary policy and forward-thinking development, Madam Speaker.
And proper law.
And proper law, as my colleague from Carinese has just reminded me. Madam Speaker, the minister must tell us what is the real rationale, Madam Speaker, for this amendment in relation to Clause 8, Madam Speaker. How many people will benefit from this order, Madam Speaker? We have not heard from the Minister of Finance. All he has said, it will benefit people. And he did not, up till this point in time, he has not really specified whether this is to assist all the Venezuelans who are in Trinidad and Tobago, all foreign nationals who are in this country. And again, he has specified or has said a short period of time, and I do not know what is a short period of time based on the behavioral pattern of the Minister of Finance for the last 4 years, Madam Speaker. Madam Speaker, the Prime Minister and his cabinet must come clean on this particular issue, Madam Speaker. And Madam Speaker, what is important is that, as I said, we must be told, or we have a responsibility to understand the importance of the national insurance system, Madam Speaker, to Trinidad and Tobago. The national insurance system currently provides somewhere in the vicinity of protection to approximately 530,000 persons, insured persons. And from a historical point of view, it was established by Act number 35 of 1971 and introduced on the 10th of April 1972, Madam Speaker. And then when it was introduced, there were only two benefits in terms of for workers at that point in time: retirement grant and the funeral grant. And on the 15th of January 1973, Madam Speaker, sickness and maternity benefits were offered, and then subsequently, the survivors and invalidity benefits were introduced within the financial year of 1974. And the retirement pension became payable on the 17th of February 1975, Madam Speaker. And currently, this system offers 23 benefits to workers in the formal and informal sector, Madam Speaker. Madam Speaker, the National Insurance Act of Trinidad and Tobago clearly states, and I quote from section 29, 1, every employer and subject to subsection 2, every employed person and every unpaid apprentice shall be registered for the purposes of the system of national insurance. 2, a person employed in any of the following employments shall be regarded as being engaged in uninsurable employment and shall not be registered for the purposes of this act. And also, it goes on to say that employment in respect of remuneration that is less than $200 a week and so on, Madam Speaker. But Madam Speaker, what is important is that how are we going to, or how the government has termed the persons who are supposed to benefit from the amendment that they are seeking to make here today in relation to the National Insurance System or the National Insurance Act, Madam Speaker. Because I read recently, Madam Speaker, an article that was written by Mr. Peter Christopher of the Trinidad Guardian, where the headline was, "The Working Rights of Migrants to be Considered." And it went on to read, migrants must be considered in the upcoming decisions of recruiting of workers bill, the Minister of Labor admitted yesterday. And Madam Speaker, she indicated, and I quote, migrant workers ought to be considered in the development of legislation. Currently, Trinidad and Tobago is faced with a situation where scores of Venezuelan nationals are fleeing their homeland and are seeking refuge here, Baptiste Primer said, Madam Speaker. And Madam Speaker, I am raising this point or this issue about the working rights of migrants in relation to our obligation under international law and the very fact that Trinidad and Tobago is a signatory to the International Labour Organization, which we subscribe to in terms of convention and recommendations, Madam Speaker. And we seem to have been flip-flopping from a policy point of view in relation to the pronouncements from the Prime Minister to ministers within his cabinet or within his government, Madam Speaker, because the Prime Minister has repeatedly used the phrase economic migrants to Venezuelans.
Vancouver South, I've allowed you a lot of leeway, and nothing here is about migrant rights. I think you were last talking about national insurance amendment. I'm allowing you a short time to tie in what you're talking about with respect to this national insurance amendment. If not, I'll ask you to move on.
Thank you, Madam Speaker. I was coming to the point in relation to our international obligation and being a member of the International Labour Organization, and the very fact that in the migrant workers under what we would call Convention 143, which was passed at the International Labour Organization in 1975, Madam Speaker, focuses on the very important issue of equality of opportunity and treatment of all from the point of view of Article 10, Madam Speaker. And I say so in the context of where Article 10 reads, each member for the convention which is in force, undertakes to declare and pursue a national policy designed to promote and guarantee, by methods appropriate to national conditions and practice, equality of opportunity and treatment in respect of employment and occupation, of social security. And, Madam, the national insurance hinges upon social security, Madam Speaker. And this is the point that I was making in relation to how are we classifying, what is the government's policy? Are they migrant workers? Are they asylum seekers? Are they refugees? And indeed, if they are
Order 48.1. Nothing in this bill speaks of migrants or refugees.
And Member for Couva South, I uphold the objection. Please continue on another point.
Yes, Madam Speaker. I am guided. I simply want to ask the Minister of Finance, who is this order designed to benefit? And that is why I am calling upon the government to come clean as it relates to the operations of the national insurance system. We cannot buy cat and bag, Madam Speaker, as our opposition. We cannot. Who is the order for? We have not seen the order on this side. And we have a responsibility to speak out. The government will not beat us in the submission here. Trinidad and Tobago is a member of the International Labour Organization and is bounded by conventions and obligations. They boast of upholding the decent work agenda, and national insurance and social security is part of that decent work agenda. And if they are not prepared to provide the information, Madam Speaker, I am forced to conclude that they are brutalizing workers, whether they are nationals or non-nationals in this country. That is the track record of the government of Prime Minister Dr. Keith Rowley, Madam Speaker. That is the track record, and that is the agenda of this government. They want nobody to have any rights in this country, whether you are a citizen or a non-citizen.
Please. Okay, so Member for Couva South, I think you could restate that, withdraw it and restate it, please.
Madam Speaker, I withdraw, but I want to tell the national population to be very wary of the government of Prime Minister Dr. Keith Rowley, who has brought retrograde legislation to this parliament that tramples upon the rights of workers. Whatever category you may want to append to them, national or non-national, you have to be wary of this government, Madam Speaker. And Madam Speaker, I want to focus on the very important issue because the minister, again, has not brought the order. As I said, we have not seen the order. And the cabinet is determined this, Madam. And at the end of the day, whoever is the office holder, His Excellency, Her Excellency, they will certainly have to ensure the implementation of the order, Madam Speaker. And Madam Speaker, I thought that in addressing the issue of the amendment to the national insurance system, the Minister of Finance, under whose responsibility the national insurance system falls under would have come very clean and very transparent in providing us with the latest update as it relates to the financial position of the national insurance system of Trinidad and Tobago, Madam Speaker. And I say so because over the last 4 years in this country, we have witnessed where, as a result of the failed policies of this government, as a result of the failure of the government to diversify the economy of this country, it has resulted in over 50,000 job losses in the public and private sector.
I caution you on Standing Order 48-1. Okay, we're not dealing with the national insurance scheme. We're dealing with a particular amendment. Tie what you're saying to the amendment, please.
Madam Speaker, I am focusing, as I said, on the amendment, and I'm also focusing as it relates to where the system will be 5 or 10 years from today, based on the fact that the fund is not getting what we would call the revenue stream, because this order will seek, Madam Speaker, to provide categories of workers, I do not know how many, and so on, to put them in a position that they will not be called upon to make contributions to the national insurance system. And Madam Speaker, the reality is that the financial position of the fund is in limbo. Madam Speaker, we must not forget that the executive director of the National Insurance Fund, Madam Speaker, and based, again, I am reading from documentation via the media, which is in the public domain. And it is not a distortion of the facts or half-truths and so on, Madam Speaker, but based on a response sent to the Sunday Guardian, the NIB's executive director revealed that Petrotrin's retrenchment would see NIB lose over $8 million a month, Madam Speaker. And in addition to that, Madam Speaker, it was indicated before a joint select committee in this very parliament on the 17th of November 2017, where the executive director told a joint select committee in the parliament that the NIB needed a 50 billion cash injection so it could make payments in the coming years. And I am saying, Madam Speaker, that the Minister of Finance lost a golden opportunity to tell us the true state of the fund, and also why a government would take a decision that would deny revenues to the fund at a time when the executive director is commenting on the financial status of this fund. Why? Much needed cash flow is coming into this particular fund, and why we are not ensuring that the law is upheld from a national insurance point of view, Madam Speaker. That is my concern. And whether, Madam Speaker, as I said, we all have a duty and responsibility to ensure in the fullest of transparency and openness and accountability at the end of the day, whether it is the working population, the future population that is to come on stream from a working point of view as it relates to this particular fund, Madam Speaker, we all have a duty-bound responsibility to ensure that it does not collapse, and the questions have to be asked to the Minister of Finance, Madam Speaker. Madam Speaker, that leads me or brings me to the very important point also, because, Madam Speaker, as I said, I am very concerned about why a government will take a decision in this particular, to deny the fund its revenue, much needed revenue stream. Is it the beginning of a process on the part of the government to mash up the National Insurance Fund and to ensure, based on this ministerial order and the long overarching reach of the cabinet every Monday morning, to interfere in the operations of the National Insurance Board, Madam Speaker? I ask the question, which direction, where we are going with this fund? My friend from Lupino, Bonnet West, your late father would be rolling in his grave because he was an architect of this fund with Dr. Eric Eustace Williams, the first Prime Minister of this country. Nathaniel Critchlow would be asking, what is the PNM of Dr. Keith Rowley doing to the national insurance system of Trinidad and Tobago, Madam Speaker? And the brutalization of the working class continues, Madam Speaker.
Point of order, 48.1, 48.6.
I will allow you on 48.1, but on 48.6, I will guide you with respect to your imputations. Okay, the language.
Thank you. Thank you, Madam Speaker. Madam Speaker, I am guided and I move on, but as I would like to repeat, we are on the opposition side, we are very concerned about the weakening of this fund and which direction the government is going. Because the Minister of Finance also lost a golden opportunity to tell the country whether there was any consultation with the labor movement, whether there was consultation with the business community as it relates to this particular amendment. And I will leave it to him and challenge him to tell us when did this take place, because we must never forget, Madam Speaker, that this fund is governed by a tripartite principle, based on social dialogue, Madam Speaker. Dialogue where it embraces government, labor, and the business community. And in the interest, this is a government that continues to boast. In fact, in his first budget presentation, he used the word consultation 32 times in his first budget presentation in this very parliament. And I want the Minister of Finance to tell us when the consultations took place as it relates to this particular amendment, Madam Speaker. Madam Speaker, we also want to ask the government of Trinidad and Tobago, led by Dr. Keith Rowley, Madam Speaker, to tell us. Yep.
Your original speaking time is now spent. You're entitled to 15 more minutes to complete your contribution, if you wish. You may proceed.
Thank you, Madam Speaker. I will continue, and based on the permission that you have given to me. And Madam Speaker, I was on the point of this fund and the implications of the government's decision. Madam Speaker, we all know that the government has a very close relationship with the business community because they have abandoned the memorandum of understanding they signed with the labor movement prior to the general elections of 2015, Madam Speaker. And every act, every form in every act.
I stand on Standing Order 48.1. And this is the second time I have stood on that, and therefore I'd ask you to become relevant in your remaining points. Please.
Yes, Madam Speaker, I am guided, and I move on in relation to the very important issue, Madam Speaker, of the decision of the government of Trinidad and Tobago. Madam Speaker, employers will now benefit from this particular amendment if it is passed, Madam Speaker. Yes. Because they will no longer have to contribute, because if an employee is in uninsurable employment, they don't have to pay national insurance contribution. Yeah. And by extension, based on the composition of the fund itself, 2/3, 1/3, employers will no longer have to pay contributions to the National Insurance Fund, Madam Speaker. And I am asking, or I am forced to ask the question, Madam Speaker, is the government sending a subtle message? Is the government sending a subtle message to employers to sideline nationals, sideline Trinidadians and Tobagonians in their respective place of employment?
You answer the question now.
Point 48.1 and 48.6.
Remember, there's a certain imputation in what you are saying, and I hold that is in breach of the standing orders. There's an imputation when you talk about the sideline, you're really talking about sidelining the law. Okay? So that I would ask you to withdraw that and press on.
Disadvantaged.
Madam Speaker, I am guided, but I have to ask the question based on the reality and what I am seeing in the public domain, Madam Speaker. And whether the government wittingly or unwittingly, based on their decision, what will be the result and the end effect in the country from a labor force point of view, Madam Speaker. That is all I am asking, and I am seeking the answers from the Minister of Finance or any member of the government side who will contribute to this debate here today, Madam Speaker. And Madam Speaker, I make the point. I will not enter the names of the employers and so on, Madam Speaker, but I have in my hand a copy of an employment form. Madam Speaker, I am not too good in Spanish, but I could...
Again, this is not relevant, and I've ruled it is not relevant to the clause that you say that you're debating on. Again, I caution you, you have a few minutes left. Either use it wisely or I'll invoke my powers. This is the last time I'm standing on 48.1.
Madam Speaker, I am guided. All I am saying in the context of the order facilitating and benefiting whom from a labor point of view.
And that point has been made repeatedly. Move on to another point, please.
Madam Speaker, also the Minister of Finance, in his presentation and in piloting the bill, focused a lot, as I said, on the issue of pensions and the issue of retiring allowances and so on, Madam Speaker. And as I come to an end, as I said early on, we all have a responsibility to ensure that workers at all levels of this country have pensions that they could enjoy a decent standard of living and a decent quality of life, Madam Speaker. And today, I also want to ask the Minister that if he has forgotten or whether he has forgotten the daily rated workers of Trinidad
Madam
and
Speaker,
Tobago.
standing order 48.1, please.
I uphold the objection.
Madam Speaker, when I am making or I attempt to make certain inquiries as it relates to my contribution to, whether it is from a collective bargaining point of view or whether it is from a pensions point of view, Madam Speaker, your end salary impacts upon your standard of living or your quality of life, beyond your retirement age, whether it is 60 or whether it is 65, Madam Speaker. And Madam Speaker, a government is elected by the people, for the people, and of the people, Madam Speaker. And at the end of the day, when we make amendments to whatever laws in this country, whatever we try to do in the interest of the people of this country must be seen to be across the board and for the benefit of all, Madam Speaker. And it is in that context I raise the issue of what is the status of the pension plan for the over 20,000 plus daily rated employees
Speaker, Standing Order
at
48,
the local
please.
government level.
Madam Speaker,
And
Standing Order 48.1, please.
I uphold the objection. Next speaker, Attorney General.
Thank you. Madam Speaker, I rise to join in this debate. I'm somewhat astounded that the first speaker was the member for Couva South because I couldn't discern a single point. I heard my learned friend stand and say, I have a serious point to make. And beyond stating that, there was none.
And we waited.
We waited and we waited for a full 45 minutes for at least one point to be made. And there was general irrelevance. But let me answer what I think my learned friend was going on to for 45 minutes, because the first part was seemingly relevant until it became irrelevant by repetition. Madam President, Madam Speaker, forgive me, I've been in both houses of Parliament, forgive me. Madam Speaker, taxation law is the one law that is allowed to discriminate. It is the one law that is allowed to discriminate. If my learned friends opposite don't know that, after a career in politics, after Couva South spent years on the tax-paying roll, receiving money working in the Ministry of Finance, as he stood as a junior minister in that ministry, if my learned friend does not know that the one law that could stand up and be completely discriminatory is the tax laws of Trinidad and Tobago, then heaven help us all, Madam Speaker. That's why you have progressive taxation. That's why you have brackets of taxation. That's why you have tax exemptions. And in applying a benefit of a tax exemption, one is entirely in the right zone in considering the social balances. So, Madam Speaker, if my learned friend is talking about some people who will benefit, that is a matter for the government in its overall policy to have benefit. If there are to be exemptions, this law applies to exemptions for all of the persons in Trinidad and Tobago who can access that relief, Madam Speaker. And all of the persons are all of the persons, full stop. We have already a full tax exemption for persons. We, as a government, lifted the bar for tax exemptions. We went from persons who were earning $5,000 a month to persons who were earning $6,000 a month.
P&M government.
This government recognized that it was unfair to have that disadvantaged class. What we recognized people were crying out for, we gave to them. So, Madam Speaker, I will just end by saying we just heard 45 minutes of gross irrelevance on an issue that can be simply answered. Let's turn to the bill. Madam Speaker, this bill is comprised of a mix of things. Quite simply, in the 11 clauses that we have before us, we effectively, first of all, have a proposal for an amendment to our long title and to our short title. We're asking, in terms of circulated amendments passed to the House since Monday of this week, that we include amendments to the Companies Act, in particular Section 516A of the Companies Act, and I'll explain that. We are proposing in clauses 2 to 6 to treat with two matters. In clause 2, we're treating with the matters of taxation, and then clauses 3 to 6 inclusive, we're dealing with the situation of retiring allowances. across legislators, the President, the judiciary, and the Prime Minister. Let's deal with just a few small points as I come to the clause 2 of the bill. In treating with taxation, Madam Speaker, in treating with taxation relief and amnesty, number one, the Minister of Finance has laid on the record the reason for the tax amnesty. That reason is as we prepare for an introduction of a number of legislative measures, it is important to give the taxpayers of this country a fighting chance to come into compliance. Number one, we intend to come with legislation on the Revenue Authority. People ought not to be shocked into compliance. They ought to be brought in a sober state into compliance. A tax amnesty to allow people to come up to mark is a useful measure that I think all citizens will welcome. Secondly, it is a matter of record that we came to this Parliament with the Civil Asset Unexplained Wealth legislation. I can tell you that today we have proclaimed the unexplained wealth sections of that act. Who has the right to ask you to explain your wealth? We recall the Commissioner of Police, the Controller of Customs, and the Board of Inland Revenue. If they are investigating a specified offense and we want to have transparency, let us not have people panicking that because they made an omission on their taxes, that they're going to have to answer on an unexplained wealth order. Let us give people a fighting chance to comply with the law. What is the relevance of this? Who's asking that? To the bill? It's in the bill. Siparia is asking what is the relevance of this. And Madam Speaker, I must say it's in the bill. We're talking about clause 2, tax amnesty. The rationale in terms of proportionality is grounded in number one, the tax structures for a revenue authority, and number two, we are announcing to Trinidad and Tobago that the unexplained wealth order sections of the Civil Asset Forfeiture Bill have come into effect as of today. And if that comes into effect as of today, and the Board of Inland Revenue has the ability to ask people to explain their wealth, well, give them a chance to clean up their taxes. Is this what the UNC has an objection to? Because we're hearing all sorts of things about who going to court and who not going to court, and there's a confusion. The first speaker in this debate spent 45 minutes talking about Venezuela. We are talking about the laws of Trinidad and Tobago. So I'm giving rationale number two. There is an important space created for people to make sure that they comply with the taxation laws. Now, let me remind honorable members this. In the Civil Asset Forfeiture Unexplained Wealth legislation, we provided a specific limitation on taxation, a very specific and important one. We said that the tax authorities ought not to go behind 6 years, so that we made sure that you didn't have to explain all of your wealth from a taxation perspective beyond 6-year period. So the message is, in harmonizing that law to the Inland Revenue Law, to the customs laws as we did in our miscellaneous provisions, that's an important rubric. But the taxation benefits, I just want to spend a moment on the retiring allowances bit as it relates to legislators. Just let me simply put, it is important to read the Retiring Allowances Legislative Services Act. It is not every legislator that qualifies. It is only legislators who have served 5 aggregated years as legislators. If you serve 4 years, you're out. If you serve 3 years, you're out. 2 years, you're out. If you served 5 years, you qualify on the lowest level of the rung, because it's a tiered system. You can aggregate 5 years. Your 5 years can be topped up by serving as a head of mission. If you serve in 1 parliamentary session, it goes up if you've served 2 or 3 or 4. So the category and pool of people that qualify in the legislative division is a very small pool. It is not the equivalent of the mass of the public service, which we are paying attention to, which we must look at in a large position, but we're talking about an extremely small pool, and we are not speaking about increasing salaries at all, as Siparia has said in the public domain. We are talking about a very small pool of people. For instance, the current Commissioner of Police, having served for 4 years before he was fired as Minister of National Security by Siparia, he will not qualify under this law. And that's an important thing to bear in mind. The second aspect is the pool of judges is equally small. And Madam Speaker, I am suggesting to Trinidad and Tobago, crime is one of the serious issues in our country and has been for a long time. In asking for judges to serve people to now populate the 77% increase in judicial capacity that we have legislatively done, you will notice there are advertisements, and the JLSC is hiring judges as we speak, but they are also fighting to retain judges. We lost Mr. Justice of Appeal Jamadar to the CCJ by way of example. One of the real concerns in the job aspects of judges is what their pensionable aspects look like. Why? Number one, judges retire, and when they leave the bench, if they have gone before retirement age, there is a 10-year limitation against practice at the bar. 10 years. And in that circumstance, we are simply saying, allow the judges an improvement in their pensions. Number one, it affects people when they retire. Number two, it's a small pool. But number three, and I say this respectfully to the fourth estate, the media, that is asking about judges. The media commendably carried the story of the tragedy of Mr. Justice of Appeal, the Honorable retired Chief Justice Clinton Bernard. There were editorials, there were articles. The Honorable retired Chief Justice published a book. He spoke to his state of mendicancy. The country was informed of the state and condition that judges live in. There are a few other judges that I can easily mention now, some who have passed from this life and some who are still alive, but out of respect for their names, I will not call their names. I see no difficulty as a society in us saying to our judges, we commend your service. We will not interfere with the Salary Review Commission, SRC's job of considering salaries. That's not our business. Let us treat with your pensions. And what are we asking to be done? We're asking for pensions to be reset to the clock every 5 years. If you qualify in the case of a legislator, and you certainly qualifying as a judge. Why? We need more judges. We need some security of tenure. And if I have to be, respectfully, the Attorney General, to take the licks, to make sure the judiciary is looked after, and if the Honorable Prime Minister is the Prime Minister that led the Cabinet to this decision, then I am pleased to take that licks, Madam Speaker, and the government is pleased to take that licks. Because this is a commendable and notable position on the legislators. The SRC, whenever the SRC does whatever it has to do, because they have not seen increases since 2005, I believe, they will take their time. We didn't sign on to this job for money. Some people have different stories to answer for in different other places. Let's confine this debate to the bona fides of the position. I have no problem in submitting that it's a very small pool in retiring allowances. Let me turn, Madam Speaker, to the Freedom of Information Act, which is the serious one for the Attorney General's perspective. Madam Speaker, I certainly apologize, just for my small individual part, in perhaps underestimating what society viewed to be freedom of information. My culpability is born on the fact that I'm very close to the information. And what seemed to be an axiomatic, easy situation of trying to harmonize the purpose of the Freedom of Information Act to make it work better, to comply with the objectives in the Freedom of Information Act in more fulsome measure, in seeing the understanding of how the taxpayers are losing money on the abuse of the system of judicial review, I recommended to Cabinet, and I take full blame for this, I recommended to Cabinet the position of making amendments to the Freedom of Information Act. The two amendments recommended are, one, allow for a slightly amplified period of time to receive Freedom of Information requests in the public authorities, and number two, allow for the Attorney General to reconsider the situation where they say no. That's it. We had proposed an amplified time frame in the original bill as published. It says 90 days on both occasions. Public society very commendably and very quickly said that they thought that that period was too large. They asked for consultation. We looked back at the period, we reformulated the structures, and we have come today to ask for the period for the public authority to be extended effectively by 2 weeks. We're moving from 30 days to 45 days. And we have said in the amendments that we propose now, when the public authority is going to say no or is going to ask for a deferral, refer that matter to the Attorney General, and only after the Attorney General's intervention does your judicial review right kick in. Now let me put this into context and into simple understanding. What time do I end in full time, Madam Speaker?
So your original time ends at 12:45:39. You're entitled to 15 minutes thereafter, which will take you to just a little after 1 o'clock.
Thank you so much. Let me break this down. Propose, first of all, who qualifies under Freedom of Information, what the time frames are, what the data looks like, and what the rationale is. The Freedom of Information Act is a commendable piece of law, brought into effect by then Attorney General Ramesh Lawrence Maharaj. It is Chapter 2202. It's an Act of Parliament number 26 of 1999. The Freedom of Information Act basically is driven by its objects and by its interpretation. Sections 3 and 4 of the Act really set out the importance and the importance, forgive me, I'm mixing two words, thank you, Prime Minister, set out the importance and the primacy of what we are supposed to be doing in this legislation. Let's look at, yes, I do speak Spanish. Let's look at Clause 3, Section 3 of the bill. The object of the Freedom of Information Act is to extend the right of members of the public to access to information in possession of public authorities. And it says generally, by the creation of a statutory right, that we're creating a general right of access to information. We're making information available about the operations of public authorities and the authorizations, policies, rules, etc. And we say specifically in 3.2 the following, and this is important: the provisions of this act shall be interpreted so as to further the objects set out in subsection 1, and any discretion conferred by this act shall be exercised so far as possible so as to facilitate and promote promptly or at the lowest reasonable cost the disclosure of information. Everything we do must be interpreted in light of Section 3.2. A public authority is set out in Section 4 of the Act, and a public authority includes all of the usual things under ministers, departments of ministries, but very importantly, it includes a body, corporate, or unincorporated entity in relation to any function which it exercises on behalf of the state. 2, which is established by virtue of the President's prerogative by a Minister of Government in capacity, etc. And 3, this is the one, which is supported directly or indirectly by government funds and over which the government is in a position to exercise control. That's an important position to bear in mind in this debate, and it is important because public authorities are not just things over which the government has control. Public authorities include the fact that there may be information in the possession of something which has, in fact, no direct government interest And I want to point out that there has in fact been a case in our courts. It is CV 2018-03189. It's the Zoological Society. It's Mahesh Das versus the Zoological Society of Trinidad and Tobago, a judgment by Mr. Justice Frank C. Prasad, November 22nd, 2018. And in that particular application, the Honorable Judge confirmed that even though the Zoological Society effectively has nothing really to do in its structure with government, because government underwrites and gives it subventions, it is deemed to be a public authority subject to freedom of information. And therefore, the public money intervention, as Caroni Central correctly says, the public money intervention causes it to fall in line with that. That's not uncommon now to what we have done in the Public Procurement and Disposal of Property Act, where we define what that law comprises supervision over. That's anybody that receives money. So the Freedom of Information Act is expanding. It is applicable to people beyond state enterprises. Now let's get to the position before we get to time. Why the Attorney General? Because I've heard people say that the Attorney General has no place in this kind of law. And I'd like to commend, for the benefit of members when they have a chance, a book called The Law Officers of the Crown. It is a particularly interesting text, which is by J. Edwards. It's a Sweet and Maxwell publication. It's a study of the offices of the Attorney General, Solicitor General of England, with an account of the Office of the Director of Public Prosecutions. And in treating with the role and function of the Attorney General in particular, we go through the medieval king's attorneys, the place of the law officers in Parliament, the burdens and repute of law officers, hybrid character of law officers, etc. And we come down to the Attorney General acting in those instances in the old Attorney General capacity, effectively as DPP, as our 1962 laws in Trinidad and Tobago had before our Republican Constitution anchored down the office of the DPP. The Attorney General exercised functions that way in both the criminal and civil arena. But what I found particularly useful, Madam Speaker, is the section dealing with the guardian of the public interest. The Attorney General dealing with the capacity of being the guardian of public interest. And I want to turn, therefore, immediately to the Constitution of the Republic of Trinidad and Tobago. And the Constitution of the Republic of Trinidad and Tobago treats with, in Chapter 5, executive powers. The executive authority of Trinidad and Tobago shall be vested in the President, and subject to the Constitution may be exercised by him either directly or through officers, etc. 75. There shall be a cabinet for Trinidad and Tobago, which shall have general direction and control of the government, and shall be collectively responsible therefore. The cabinet shall consist of the Prime Minister and such other ministers, one of whom shall be the Attorney General. Section 76 goes on to treat with the appointment of ministers, and 76.2 says, the Attorney General shall, subject to Section 79, be responsible for the administration of legal affairs in Trinidad and Tobago, and legal proceedings for and against the state shall be taken. A, in the case of civil proceedings, in the name of the Attorney General. B, in the case of criminal proceedings, in the name of the state. Now, this Constitution is the supreme law of Trinidad and Tobago. When we turn to the further provisions of the Constitution, and we look particularly at Section 53 of the Constitution, the powers, privileges, and procedures of Parliament, Parliament may make laws for the peace, order, and good government of Trinidad and Tobago. So we come here today, anchored by the Constitution, saying that the Attorney General has constitutional role in Section 76.2. Parliament may make laws for the peace, order, and good governance under Section 53. And in this bill, in Clause 7, we are introducing the Attorney General as a reviewer of refusals. Let me repeat that. As a reviewer of refusals for requests for public information under the Freedom of Information Act. Only refusals that are already made by public authorities. Now, there are 2 points that I want to get to. Number one, what the public authority and interaction with the Attorney General looks like, and number two, the data. So let's deal with that. I've just pointed out that the Attorney General has that capacity. But when we turn to two very important pieces of law, number one, we treat with the Judicial Review Act, and secondly, we also treat with the State Liability and Proceedings Act. In the State Liability and Proceedings Act, in treating with that Act, Chapter 802, we effectively constrain the state to a very narrow interpretation, which does not include state entities, because we specifically exclude a whole category of positions under the State Liability and Proceedings Act. When we go to the Judicial Review Act, and the Judicial Review Act is the thing that works in tandem with the Freedom of Information Act, how Section 23 of the Freedom of Information Act says if you get a refusal, you have the right of judicial review. The Judicial Review Act, Chapter 708, is designed so that you must get the leave of the court under Section 6, and effectively, the Judicial Review Act says nothing about referring to the Attorney General. It says nothing. However, as the practice has grown up specifically, we note that the judicial review by rules of practice and rules of court now require us to take a different point of view. So the JR Act in the year 1999, operationalized fully by 2002, had no reference of all public authorities going to the Attorney General's office, but Part 56 of the Civil Proceedings Rules specifically contemplate certain referrals. That's subsidiary legislation. And very importantly, the case of Motilal Ramsingh versus Eric James and others, it's a civil appeal pending at present, number S307 of 2015, which involves 3 matters on appeal. Rule 5610(4), basically as interpreted by the court, says the Attorney General, where there are judicial review proceedings and the Attorney General is not a party, there's a duty to serve the Attorney General. So we have the cases in the courts now saying, even though the JR Act is silent on sending all JR matters to the AG, the courts have now said, where the AG is not a party, serve the Attorney General in judicial review matters. So let's get to the data. Madam Speaker, what are we talking about in freedom of information? The data tells us that the last annual report under the Freedom of Information Act was in the year 2008. That was the last date that it was laid. The Honourable Minister of Communications, the member for Port of Spain North St. Anne's West, is in the course of tidying up those publications because none were made for the entire time that the UNC was in government or for the years that we have been in government. We aggregated that data and it's about to be published. But what I can tell you, Madam Speaker, is that in the period 2009 to 2016, firstly, the numbers look like this year on year from 2009 to 2016. 1,221 filed requests in 2009. 2010, 1,556. 2012, 315. 2019, 818. 2014, 869. 2015, 532. 2016, 899. The number of decisions where people were deemed not entitled, from 2009 it was 128, 2010 68, 2012 14, 2013 106, 2014 37, 2015 139, 2016 145. Let's put that in statistics. The number of yeses as a percentage in 2009 was 89.5%. Yeses. 2010, 95.62%. 2012, 95.55%. 2013, 87%. 2014, 95.7%. 2015, 73.8%. 2016, 83.8%. But when you look at the statistics, remember the numbers are different. So 114 out of 315 will obviously give you a skewed ratio as opposed to 128 out of 1,221. The number of no's that we're dealing with that went to judicial review 2009, 9 went for judicial review. 2010, 7, 12 of them. 2013, 10, 2014, 7, 2015, 99, 2016, 187. There's an uptick. In other words, the percentage that actually made judicial review, 0.7%, 0.4%, 3.8%, 1.2%, 0.8%, 18.6%, and 20.8%. So the data demonstrates that the yeses are in the vast majority. The noes, which actually go to judicial review, are on the average, in most years, under 1%. Until, of course, an industry of exploitation started. Now, I'll tell you, Madam Speaker, the list of freedom of information, JR matters in the Office of the Attorney General right now is that we have 124 of them. Of that 124, only one comes from a non-government entity. It's SwimCall, 1 out of 124. And the numbers that come from the judiciary tell us effectively that the judiciary on its quarterly basis, and I got the most recent quarter, for the period January 1st, 2019 to March 31st, 2019.
Your original speaking time is now spent. You're entitled to 15 more minutes to complete.
Thank you, Madam Speaker. I'll be quick. I'll try to speed up. 54 matters filed under the FOI. This is from the judiciary. And 49 of them were disposed of. But when we look to the numbers, we see that if a JR is filed in the year 2018, it's disposed of in 2018. If it's filed in 2019, it's disposed of in 2019. So there's a relatively quick turnover. But, Madam Speaker, there are 2 attorneys at law in particular in the period while this government has come into operation that have made millions of dollars in milking the taxpayers on judicial review applications. I'm going to name them because they're not members of the House or Senate. Anand Ramlogan, self-appointed senior counsel, and Gerald Ramdeen. I'm very grateful that NAPRIMA believes that persons who are on criminal charges are the best that the UNC has to offer. Correct. But, Madam Speaker,
why is it 48-6?
They're not members. Look, sit down.
No.
One minute. Any member is entitled to raise a standing order. The Speaker will therefore rule on the standing order. Please continue, Attorney General.
Repeat that. Gerald Ramdeen, ex-senator of the UNC, Anand Ramlogan, according to NAPRIMA, the best AG that the UNC could find, these 2 fellas on the record are in a very difficult situation. And, Madam Speaker, all that I could say, I say my prayers, I don't relish in that, but what I can say is in relation to this bill and Clause 7, these 2 gentlemen have made a career of milking the taxpayers. I want to be very careful. They have done nothing illegal. Let me be absolutely fair to these 2 gentlemen. They have done nothing illegal at all. But knowing the state system and its vulnerability and the loophole of exploitation, they have legitimately brought freedom of information applications. They are entitled to have done that. In a lot of instances, it feeds other causes. But, Madam Speaker, the question is, how much is this costing us, Madam Speaker, as a country? How much is this costing the taxpayer of the countries? Madam Speaker, could you control NAPRIMA? Madam Speaker, in terms of costs, I want to give a few examples. I will firstly give the case of Singh versus the PSC. This is a case, Madam Speaker. Listen to the facts of this case. Mr. Singh, an appellant in a particular matter, on January 2016.
Members cannot sit back in a relaxed and retired position and shout questions across the floor. There is a standing order for interjections. Employ it properly. I caution the whip, you are supposed to be an expert on the application of the standing orders. Attorney General.
Madam Speaker, Singh versus the PSC, from the Court of Appeal of Trinidad and Tobago before the Privy Council, 13th May 2019, heard on the 25th of March 2019, Easter term, 2019 UKPC at 18. In the case of Singh versus the PSC, listen to the facts. On the 27th of January 2016, Mr. Singh made a Freedom of Information request. On the 11th of July 2016, the PSC provided him with some of the documents. On the 18th of July 2016, an application for judicial review was filed. On the 26th of July, 8 days later, the application was withdrawn. This matter resulted in the Privy Council observing that the PSC was trying its best to get information. They could have been more organized in how they communicated that, but the issue of how much was to be awarded in terms of costs went all the way to the Privy Council, because the High Court said pay them $7,500 in legal costs. It was appealed, that cost order was set aside, it went to the Privy Council. And in getting to the Privy Council, Madam Speaker, the costs have not yet been assessed in that matter. Going to the Privy Council is not cheap. The same attorneys at law taking a matter to the Privy Council will result in $1 million award of costs on a Freedom of Information matter where the information was provided 8 days after the filing and the matter was withdrawn. That's example number one. Example number two. Brief, let's listen to this one on Vijay Singh versus the Ombudsman. CV 2016-01485. Mr. Singh, who is employed at the Ministry of the Environment and Water Resources, applied under the FOIA to the Office of the Ombudsman. He failed to receive a response in January 2016. He submitted his FOIA request under Section 13. In February 2016, the Ombudsman refused to provide the information. The information was subsequently given to Mr. Singh by the Office of the Ombudsman in November 2016. Take a guess what the bill in that is. Same UNC attorneys. The bill Mr. Ram Logan, etc., have offered as the bill to be paid in this matter is a small $1.7 million in costs. $1.7 million in costs. Let's deal with two more matters. And by the way, the attorney at law acting for the Parliament charged $10,000 for the case.
That's correct.
Right?
That's correct.
A fellow by the name of Roger Kewal Singh, who acted for the Parliament, charged $10,000, and Ram Logan and Ramdeen won $1.7 million for the same matter. Just giving you the comparison. So, Madam Speaker, Daryl Hiralal versus Ministry of Finance. Madam Speaker, we had two cases involving Ministry of Finance. We had CV 2016-01313, and we had CV 2016-02495. In both cases, Mr. Ramdeen was the attorney at law. In both cases, the matter ended in withdrawal of the proceedings. In both cases, the bill was $200,000 a pop for withdrawn proceedings. And let me say this. The Office of the Attorney General, through the Solicitor General's Department, attended at court and consented to that without receiving the express authorization of the Attorney General.
Wow.
I had to implement a direction in the SG's department to say no consent order is to be entered without my express written approval, because that matter should have cost the taxpayers $14,000 a pop. It ended up costing $200,000 a pop. Wow. Madam Speaker. Madam Speaker. Yeah, let's deal with the witness statements matter. For once, Naparima making sense. Let's deal with that. Let's deal with the case of Ravi Balgobin Maharaj versus Petrotrin. Madam Speaker, in that particular matter, I see time going quickly. Effectively, Petrotrin was under a Freedom of Information request. There was a suppression of evidence by Anand Ramlogan, acting as AG, did not provide information to counsel, Queen's Counsel Vincent Nelson in the Malcolm Jones matter. That suppression of evidence resulted when there was a claim for discovery, a specific discovery application in that matter. The Queen's Counsel was told for the first time by the instructing attorney and Gerald Ramdeen as junior counsel, look, we have these things to disclose. Queen's Counsel rolled up and said, I've never seen these
Madam
things.
Speaker, 49,
and they affect
please.
my advice as...
Standing Order 49, sub judice.
So, Madam Speaker, in this case, which has gone to Privy Council and is ended, Madam Speaker, effectively, the government held the view that the witness statement should have been revealed. The government was never told of the Freedom of Information application. The government, when that matter came up, because Petrotrin was not required...
Madam Speaker.
I have 5 minutes. Madam Speaker, just have 5 minutes. I'll rally it. Madam Speaker, the government was never told, because Petrotrin has no obligation to tell the government under the law. And Madam Speaker, that matter cost us, in actual fees, $1 million, and we are exposed to about $2.5 million in legal fees. The Honorable Prime Minister intervened publicly and said that situation needs to be addressed, give the witness statements. But Madam Speaker, that judicial review application has taken us to $3.5 million in costs. Again, the lawyers in this matter are UNC, Anand Ramlogan, Gerald Ramdeen, today one day, today another day. And Madam Speaker, even though they've done nothing unlawful, they're milking the taxpaying system. So Madam Speaker, let's get to why we want this law to prevail. We are saying, Madam Speaker, that the Attorney General is the head of ministry of the judicial review applications. All litigation matters come to the desk of the Attorney General. There is nothing that the Solicitor General does that does not come to the Attorney General's attention. We are saying in this system of milking the taxpayers that in the situation where you have a no from the public authority. For example, Petrotrin said no, let Petrotrin, at the same time you tell the applicant for the information no, tell the Attorney General that you have said no, provide those reasons. And let the Attorney General have 30 days only before your judicial review application kicks in. What does this mean in a simple sense, Madam Speaker? It means that we improve the chances of a yes. So the no's are currently, in terms of judicial review applications, 0.7%, averaging under 1% until Mrs. Ramlogan and Ramdeen enter the equation, where the figures jump, costs jump. We are saying now, to improve your chance of a yes, let the Attorney General be aware. Because why, Madam Speaker? Let me put it very clearly. Currently, Part 56, and currently the case law demonstrate, in the case of Ramsingh versus Eric James, they demonstrate that the court is going to tell the Attorney General anyway when the JR is filed. Come and be aware of it. So the court has already gone a further step. The court has already said, tell the Attorney General when a judicial review is filed. We are simply saying, tell the Attorney General when you say no and before you file. And allow the taxpayers a fighting chance of 30 days so the AG could ease up the taxpayers in terms of what Ramdeen and Ramlogan are doing. And it's as simple as that. And respectfully to everybody that can't understand that situation. Number one, the judicial review right is preserved. Number two, we are saying tell the Attorney General before and after. The court already went on to say tell you after. Part 56 of the CPR and the case before Mr. Justice in the Eric James case, tell the Attorney General. So, Madam Speaker, there is very little to consult on that. Because, Madam Speaker, I can tell you that the Minister of Communications, having finally got the freedom of, the control of information, the information, freedom of information has a cohort in the data protection legislation, and the Information Commissioner is a very useful position there. The government was hamstrung until the Minister of Communication pushed for the SRC to complete its works. The Cabinet has considered the improvement of the Information Commissioner, and whilst the Minister of Communications is building out that division, in the meanwhile we say carry logic a natural step and allow the Attorney General the opportunity to review the positions. And for those who are outside there saying the Attorney General has no place in this business, read Section 76(2) of the Constitution. And don't come with the nonsensical argument of politics. Because, Madam Speaker, the fact is that our Constitution has stood the way it has. Prior to 1976, the AG's role was even more significant when the DPP's factor was rolled up into one. So, Madam Speaker, the simple point inside of this is that there is merit in this. Now, Madam Speaker, just permit me very quickly to touch upon the Companies Act and the Non-Profit Act. We have proclaimed both pieces of law. We are asking for the date for the implementation of penalties to be moved other than by way of an act of Parliament. Section 516A is cast in stone and NPO cast in stone. What we are saying is let that be extended by order. Why? We are accounting to that to FATF on Sunday morning when I appear before them. So, Madam Speaker, I reject out of hand the arguments of the UNC bench. I think that this is a rational argument to ensure that exploitation ends and that we protect taxpayers. I end by saying the UNC said nothing when a retiring banker took home $13 million in a parting gift under Kamla Prasad Visesa. And I thank you, Madam Speaker.
Honorable members, it is agreed. Honorable members, agreed that we will take lunch at this time. So this sitting is now suspended. We shall return at 2 p.m.